The Michigan versus Dante Adams, 26-01391. Have your appearance, please.
Good morning, Your Honor. My name is Robert Ianni, and I'm Special Assistant AG on behalf of the people.
Assistant Public Defender John Lee on behalf of Dante Adams.
Okay, Ms. Harris was scheduled today for preliminary examination. My understanding is that there is a unconditional waiver to circuit court. Is that correct?
Yes, Your Honor.
Is there any offer or negotiations?
The people have made the standard offer in this case. The defendant has an arrearage of child support of $15,937. The offer in these cases is 25%, $184. He's guilty. The people will agree to an 11-month delayed sentence. During the delay, if he's able to pay 50% of the arrearage, charges are reduced to an attempt. If he's able to reduce his arrearage to zero, the charges are reduced to a misdemeanor.
That's my understanding.
Okay, Mr. Adams, that's your understanding?
Yes.
Okay, you understand that you have the right to have a preliminary examination on these felony charges?
Yeah.
You understand the purpose of the preliminary examination? You have the right to require that the Attorney General establish sufficient probable cause that these felonies were committed and probable cause sufficient to charge you as the individual who committed the felony. Do you understand that? You wish to unconditionally waive your examination?
Yeah.
Anyone threatening you to do that? Any promises to get you to waive your exam? Your bind over date is July 29th. That's the date the circuit court's going to receive this file, not the date that you need to appear in court, okay? Your next court date will be a pre-trial. Once the circuit court receives this file, it will be sent and your attorney will be made aware of that date. Do you have any questions at this time? A bond is set at $3,984 cash only. That will continue. Any additional matters for the record?
We do ask, Your Honor, that there's a history of domestic violence in this case and no contact with the custodial parent.
There is a no contact order with Courtney Lightheart. That will continue.
Thank you.
No problem. Any additional matters?
No, thank you.
Thank you. You're all set.
Thank you, Judge.
Let's say mixes a waiver, she can be one.
Mitch.
Yes. State of Michigan versus Darnell Gardner, 26-01696. Appearance, please.
Ross Marchino to the people. Good morning, Your Honor. Assistant Public Defender Stephen Feigels on behalf of Darnell Gardner, standing to my right today, Your Honor.
Mr. Gardner is scheduled for a preliminary examination on controlled substance delivery manufacturing, 5,499 grams. And there's a waiver of this to the circuit court today.
That's correct, Your Honor.
That is correct.
Okay, previously I had noted that there was an offer to dismiss the habitual court offender notice. Is that still the offer or is there a new offer?
We have a new offer in which the charge would be reduced to PWID less than 50 grams, and the habitual offender notice and any sentencing agreements will be worked out in the circuit court.
Mr. Ferguson.
Your Honor, that's an accurate statement of the offer conveyed to Mr. Gardner this morning that Mr. Gardner does wish to waive his right to exam on that offer and negotiate.
Okay, so Mr. Gardner, you understand the right to have a preliminary examination, correct?
Yes.
You want to waive that?
Yes.
Anyone threatening you to do that?
No.
So you understand the waiver is unconditional, so you will give up your right to require the prosecution establish probable cause that a felony was committed and probable cause to charge you as the person who committed the felony. You understand that?
Yes.
Your bind over date is July 29th. That's the date the circuit court's receiving this file. Why does every time I get to that point, every single defense attorney starts talking to them, like every time? Why do you all do that?
Sorry, Judge, mainly just to ensure he knows not to be a court. I apologize.
What do you think I'm talking about right now?
I apologize, Judge.
Can you listen to me and you all at the same time? It's not just you, it's, I watch every time I do it. When I get to that point, we all start whispering in their ear, which means you diverted their attention. And
I
you
can't
have-
answer for anybody else. I just do it out of habit.
Yeah, I think you all have the same habit, and I think you all gotta stop doing that. Because you can't listen to me if he's listening to you. And you're doing it as I'm telling him he does not need to appear in court on that date. That's the date the circuit court's receiving the file. Okay? They'll then reset the date for your pretrial. Your attorney will be made aware of that. Do you have any questions? A bond was set, 15,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing from the people.
Nothing else on behalf of Mr. Gardner today, Your Honor.
Thank you. You're all set. State of Michigan versus Nathan Kright, 26-01084. Is Nathan Kright here? I'm assuming, no, is he already on probation? I mean, probation status. State of Michigan versus Toronto Lee, 26-01189. Mr. Raleigh here? Mr. Raleigh?
I'll step out and give you a call. Mr. Feigelson reports that Mr. Raleigh might be examined in the court.
All that case when he's back. You can have a seat for now, sir. State of Michigan versus Dante Loudon, 26-01725.
Ross Marchmead on behalf of the people.
Schroeder here?
Probably.
Ms. Schroeder is likewise tied up elsewhere.
Okay.
It sounds like we're ready on Lori Tedgel. Lori Tedgel, Tejkl.
That's the state of Michigan versus Textual 26-01569. Appearance, please.
Ross Marchmead for the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Lori Techko, on behalf of Mr. Harris, Your Honor. Harrison, who I think believes in the court.
Okay, and this is an exam for animal abandonment cruelty. How are we proceeding?
Your Honor, it is the people's understanding that both parties intend to unconditionally waive the preliminary examination. It is my understanding that Ms. Tedgel will be evaluated for eligibility for the Third Circuit Court Mental Health Court.
Mr. Ferguson?
Your Honor, I believe that's an accurate statement from what Mr. Harrison conveyed to me. And I believe Ms. my client wishes to waive her right on that offer. Is that correct?
Okay, Ms. Touchful, you understand your right to have a preliminary examination on this felony file? And you're willing to waive your right to require the prosecution establish that they have sufficient probable cause that a felony was committed and probable cause sufficient to charge you, Mr. Marshmina, with the felony? Thank you. Anyone threatening you to do that? Is anyone threatening you to do that? No. Has there been any promises extended to you in exchange for your waiver, ma'am?
May I approach the file?
Yes, thank you. Right over date is going to be July 29th. That's the date the circuit court's going to receive this file. It is not a court date for you, okay? Your next court date will be in circuit court, but it will be a pre-trial, and your attorney will be made aware of that date. So you maintain contact with him, okay? If you have any questions at this time? No. Bond, I was set at 1,000 personal recognizance. That will continue. You're also not allowed to possess, care, or be in control of any domestic animals. Any additional matters for the record?
Nothing from the people.
Nothing else to pass on my client, man.
Thank you. We're all set on this one. And this is Miss Mix.
Yes.
But we don't have this renunciation.
That's going to be a waiver. My understanding is Mr. Feigelson did.
Oh, okay. State of Michigan versus Alyssa Mix, 26-01750. Yes, Chris.
Ross Martin on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Miss Nix and behalf of Ms. Rowland. Good morning, Your Honor.
This Mix is scheduled today. Mr. Marshall, you can approach for a preliminary examination on assault with intent to do great bodily harm. There's going to be an unconditional waiver, is my understanding.
That is correct, Your Honor. There is not an offer to place on the record at this time. Negotiations will take place in the circuit court. I'll note for the record that the complaining witness did appear and is present in the courtroom, but in this particular case, we were not concerned about preservation of the record.
Mr. Ferguson?
Yes, Your Honor, I believe that's an accurate statement from speaking to Ms. Mimic. She does wish to unconditionally waive her exam that would be as opposed to ensure the presence of this hearing.
Okay, Ms. Mix, you do understand your right to have a preliminary examination, that's correct? And you understand that if you waive it, it's unconditional, you understand that? Yes. So you won't have your hearing in the district court if you waive your exam. That requires the prosecutor establish sufficient probable cause that a felony was committed and then sufficient probable cause to charge you as the person who committed the felony. You understand that? Yes. Anyone threatening you to waive your exam? Has there been any promises in exchange for a waiver? Find over date is the 29th of this month. That's the date we send the file to the circuit court, not a court date for you, okay? Your next court date will be a pre-trial in the circuit court. Your attorney will be made aware. Do you have any questions? A bond is set at 11,000 cash surety with GPS tether and no contact order. That will continue. Any other additional matters today?
Nothing from the people.
Nothing on behalf of the client, Your Honor.
You're all set. Let's see, Mr. Austin is here. We can bring, do you want Padilla or Sanders first?
Yes, fine.
Padilla, please.
Have a nice day.
Have a good one. Thank you. Mr. Amadeo, are we running Wilson?
Yes, Your Honor, we are.
I didn't say that.
You did have.
Ross, do you want to approach this so that we get done with it?
Oh, I don't think we can verify that it's CPL. Randy's here. So I saw that the report didn't say whether or not he's got CPL. He was working security guard. We had a valid reason to have it. That's why it wasn't wrong. It's just-
On the record in the matter of the people of the state of Michigan versus Dante Loudon. 26-01725.
Ross Marshman on behalf of the people.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Loudon. Mr. Loudon is here in person, and I will be standing to his right here momentarily. Thank you.
Thank you. Mr. Loudon, you can remove your hands from your pocket. Okay, Mr. Loudon was scheduled today for a preliminary examination, but I see there's been an offer. Extended use of controlled substance. Is that what he's going to accept today?
It is, Your Honor.
Do we have the license rights yet?
I don't believe we had one done yet because he was on Zoom when he was here the last time for it. I can. Is that, all
There should be some over there.
right, thank you.
Didn't mention.
Thank
No.
Here's-
We're special. That's why
Get your answers to make sure. Thank you.
Want to adjourn to the verification?
This is verification.
Is that verification?
Your Honor, if I may approach.
Yes, Tim. Okay, Mr. Loudon, please raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury. Are you okay? Why are you holding your stomach?
I'm not.
Oh, okay.
I'm just saying that. I don't know.
Oh, okay. I didn't know if you were sick.
Oh, yeah. No.
Okay, you understand that you have the right in this, you can put your hand down. You understand that you have the rights listed here?
Yes.
Okay, this is your signature, correct?
Yes, it is.
Can I put today's date on this document for you? Okay, so you understand that in order to plead guilty, you would have to waive each of the rights listed here. That means you're giving up your right to the presumption that you're innocent. You're innocent until proven guilty. You can maintain your innocence take this to trial and require that the prosecution prove your guilt beyond a reasonable doubt. You have the right to see, hear, or question any witness that the prosecution calls to testify against you, the right to subpoena witnesses that will testify on your behalf, the right to present evidence that you believe show a defense to this charge, and the right to remain silent and not have silence be used against you. However, you can take the stand and give testimony at the trial if you want to waive your silence. You understand that? Is anyone threatening you to get you to give up these rights? Has there been any promises extended to you in exchange for you to enter a guilty plea today?
No.
Are you on probation or on parole?
No, I'm not.
Do you understand that by pleading guilty, it could result in a conviction that you may need to report to a current employer, or you might need to put this conviction on a future job application? This conviction could also impact where you can travel or seek immigration status in the future. So you may want to go out the country somewhere, and they can deny you entry into their country because you have a criminal conviction. You understand that? And no one's forcing you or threatening you to plead guilty, correct? As to the amended count of use of a controlled substance, how do you plead? Is that because you believe that you're guilty? Factual basis, please.
Thank you, Your Honor. Mr. Loudon, back on June 30th of 2026, were you pulled over by the Lansing Police Department?
Yes, I will.
And the reason for that stop was for your headlights and your taillight or your taillights were not working at that time, correct?
Yes.
And the officers interacted with you, came to find out you did not have a driver's license, is that correct?
Yes.
And at that time, they removed you from the vehicle for that, is that correct? And because the vehicle had to be towed, is that correct? Okay, and at some point there was a baggie found near your seat, the driver's seat, is that correct?
Yes.
And that had some drugs in it, correct?
Yes.
And that was methamphetamine, correct? And you had that because you'd been using methamphetamine.
Yes.
Okay, and you knew it was methamphetamine, correct?
Yes.
And you don't have any special reason or legal right to use methamphetamine, correct?
Yes. No.
No, okay.
Nobody does.
No, you knew what it was, but you
Yeah,
knew
I
that you didn't
know
have a
what it
right
is.
to use it. It was illegal, correct? All right, thank you, Your Honor. If the court or the prosecutor have any questions?
People are satisfied.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be freely, voluntarily, and intelligently made. Your matter is set for sentencing September 10th at 9 a.m. You need to go down one floor when you get to meet with our probation department so they can get you scheduled for a pre-sentence interview. I'm also ordering a substance use assessment prior to sentencing.
Your Honor, we're just looking up right now to see if he's eligible for 7411 potentially. No, 7411 is first time drug offense. So we're just taking a look. I just thought of that. Okay, then I think that would disallow him. Potentially, no. Okay, so
Nothing else for the record, Your Honor. Thank you.
I think there might be a conviction that would disallow him, but I'd still ask him for if he is otherwise eligible for 7411 consideration, but he may have a conviction that may be unavailable. Thank you.
Nothing for me to check in the box. Probation will let me know.
All right, great.
Thank you.
No problem.
Thank you.
Any additional matters for the record?
Nothing from the people.
Okay, have a seat and we'll get you downstairs when the officer's available, okay?
Oh, did he have a sentencing?
September 10th.
Jeez, my brain is.
No worries.
Sorry.
Okay, are we ready on Wilson? Oh, no, who did we bring up? Padilla.
Yeah.
That one first. Okay, State of Michigan versus Joseph Padilla Jr., 26-01684. Yes, please.
Ross Marchman on behalf of the people.
Your Honor, good morning. Jared Austin appearing on behalf of Mr. Padilla, who is now with me at council table.
Okay, this is a home invasion first and this aggravated stalking exam. Are we continuing or how are we proceeding, I should say?
Your Honor, the people, we will be conducting the exam.
Lists you have,
Just one.
you ready?
Yes, we are ready, Your Honor. I would just note that Mr. Padilla would be willing to waive his right to the exam. My understanding is that people wish to exercise their right to conduct the exam.
That is correct. After consulting with the victim in this matter, we did decide to go ahead and conduct the exam.
Sorry, witness.
People call Brittany Padilla.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Think you can have a seat? That microphone again will not amplify your voice. It'll only allow the system to pick up all of your responses so that a recording can be made. So a transcript can be produced as part of the court process. So all of your responses must be loud and clear so we can hear your verbal response. No head nods, head shakes, mm-hs, uh-huhs, because we need yes or no responses to be clear in the record. And then if either of the parties say objection, you'll stop speaking. I'll make a ruling, then I'll tell you if you can give us the answer or not, okay? State your first and last name and spell both, please.
Brittany Padilla, Brittni, T as in Paul, A as in Apple, D as in dog, ILLA.
All right, Ms. Padilla. Obviously, you were here a couple weeks ago, but I do need to re-ask some questions because it's a new record, okay? Do you know someone named Joseph Padilla?
I do.
How do you know Joseph Padilla?
He's my husband.
How long have you guys been married?
I'll say almost 20 years.
And do you see Joseph Padilla in the room right now?
I do.
And could you please tell me where you're sitting and describe his clothing?
He's sitting to the left of me. He has on blue with the ponytail.
Your Honor, could the record reflect the witness to identify the defendant?
Any objection?
Without objection.
Identification is noted.
Now, do you have a civil personal protection order out against Mr. Padilla?
I do.
And if you were to see a copy of that document, would you recommend it?
I will.
Your Honor, may I approach the witness?
Yes.
All right, approaching the witness with Peoples 1. And do you recognize that document?
I do.
And is that the civil PPO that you have against Mr. Padilla?
It is.
Your Honor, at this time, the people move to admit Exhibit 1.
Any objection?
Without objection.
Exhibit 1, you need it.
Right, may I see that? And just correct me if I'm wrong, it looks like the date of this is July 9th, 2025, is that right?
Right.
And then over here in paragraph 9, does that indicate that it's effective immediately?
Right.
And then is the expiration date on that July 9th, 2026?
That's correct.
And then finally over here, does this indicate proof of service on the top?
Right.
And is that date on the service August 9th, 2025?
Right.
Your Honor, may I approach?
Yes.
Publishing Exhibit 1 to the court. Now, do you remember January 15th of 2026?
Somewhat of it, but I do remember it.
And on that day, did you find yourself at 1104 Persons Court?
Yes, sir.
Is that in the city of Lansing, County of Bingham?
Yes.
And what is that location to?
Um,
And can you sort of describe what kind of structure your home is?
a two-story house.
So is it a single family house?
Yes.
And did there come a time that day when you saw the defendant in or around your house?
Yes, he's in the driveway.
And had you invited him over to your driveway?
No,
And what time of day was this?
this was probably around, I was getting ready for work that day, I believe. Maybe like around 11, I believe it was at 11. Something, so,
And at this point in time, you were preparing to go.
yes, sir.
And when you first saw him in the driveway, did you do anything about him being there?
No, he was outside. I didn't do anything wrong. He just said outside.
Now, was there a time after that when you heard him saying anything or doing anything?
No, I heard the door open. Because prior to that, I went to the store. I left my door unlocked. He was nowhere around then. And then I was upstairs getting dressed for work, so my door wasn't locked.
So while you were getting dressed for work, that's when you heard the door open. And then did you come to have reason to believe that someone had entered your house?
Yes, I heard it. Because my bathroom is like, walk up my stairs, and my bathroom's right there. So you can see who's coming up the stairs.
Who was coming up the stairs?
Joseph was coming up the stairs.
And at this point in time, had you invited him?
No,
And that personal protective order that you saw earlier, does it bar him from being in your home?
exactly. Yes, sir.
And was he saying anything as he was coming up?
Well, he was running towards me. He said, "I'm tired. You cheating on me, bitch." And then he ran to grab my neck. And that kind of threw me to the window. But at that time, my coworker was coming. She came in the house and stuff. So he kind of like left. Said he was sorry or whatever. Then he ran out the house and she came. The police came and we both gave statements.
Okay, so breaking that down one step at a time, you said he ran up to you and then grabbed you by the neck. And when he grabbed you by the neck, at any point did that affect your breathing at all?
No, it was kind of like one of those.
Okay.
Pushed me towards the window.
And so he pushed you towards, you basically used your neck as a place to put his hand pushing you. And then how quickly after that did your coworker arrive?
Yeah, I was saying maybe like 5 or 6 minutes later.
Okay. And what was going on between the two of you, between him putting his hand on your neck and his coworker?
He was leaving. I think he was already gone when she came. But I told her what had happened.
Okay.
So normally she sits in the driveway in the car with me to come outside. I told her what happened. She came inside. I called the police and then we waited for them to come.
Okay. And at what point did he say anything when he left? Did anything happen?
Just, I'm sorry. That was it.
Okay, so he shoved you in the back and then said, "I'm sorry," and then left. All right, no further questions.
Last examination.
Morning, Mr. Diaz.
Come on.
So as I understand it, this first time that you saw Mr. Padilla on that day, he was just in your driveway, is that correct?
Correct.
He wasn't doing or saying anything that caused you any type of alarm at that point, is that right? Wasn't trying to do anything harmful to you or come into the residence or anything at that point, is that right?
Correct.
He wasn't yelling or causing a scene or anything like that, is that correct?
Yeah.
And for the time that you saw him in the driveway that you weren't really concerned about until the time that you heard the door being open, what kind of a passage of time are we talking about there?
I can't really remember because it was so long ago, but he does that sometimes, but he does never threats. But I can kind of tell he was belligerent. So.
Well, let me ask you this, would you be able to even approximate to say it was 10 minutes, 30 minutes, an hour?
I say maybe about 45 minutes, I can say.
Okay. When you first saw him in the driveway, that didn't cause you to lock the doors or call the police or anything like that, is that correct?
Correct.
And when you saw him in the driveway, you said this was around 11 or 12 o'clock?
I believe so.
And that's in the morning that we're talking about?
I believe so.
And you were getting ready for work at that time?
Mhm.
Is that a yes?
Yes, sir.
So I take it you work some type of afternoon or second shift job?
Second shift.
And you said you've been married to Mr. Padilla for roughly about a couple decades, is that correct?
Correct.
Okay. And you've certainly had the chance to observe him and the way he appeared to you and the way he was acting on this day, is that correct?
Correct.
And from what you could see and observe, it appeared to you that he was under the influence of something at this time?
Correct.
And you did not seek any type of medical attention after this incident, is that right?
No, I didn't.
Okay. And the police would have asked you about that or afforded you that
Yes,
opportunity?
they did. I didn't do that.
And you said your coworker had arrived. What was your coworker's name?
Casey Bywater.
Do you know how to spell Casey?
It's Kasey.
Do you know if Casey gave a statement to the police or do
She
you know?
did.
All right. Thank you, man. That's all the questions I have, Your Honor.
No redirect, Your Honor. Thank you.
Thank you, Ms. Padilla, you may be excused.
Your Honor, the people rest.
Will be any defense witnesses today?
We'll rely on the evidence presented, Your Honor. Thank you.
You can make your argument.
Okay, we have in this instance 2 felony counts and a misdemeanor domestic violence second offense. So regarding count 1 is one I'll be discussing at this point. Count 2 is aggravated stalking as expected. Something Mr. Ross and I discussed. It seems as though in this instance, there's only 1 contact, so we will be moving to dismiss count 2. Of course, there is still an aggravated stalking in the case that was found over 2 weeks ago. And then of course, count 3 is a misdemeanor that does not require any findings from this court at this time. And so we will be discussing count 1, which is first degree home invasion. I'll be relying on jury instruction 25.2C. And I'll note at the outset, we did establish both ID and venue. First, the defendant entered a dwelling without permission. So we're going under the entering without permission theory because clearly there's no evidence he goes and entered. It's very clear that he entered, and as far as without permission, first off, the testimony was clear that she did not invite him in, even if she had. We of course have Exhibit 1, which is a personal protective order that had been served prior to this date, making it very clear that he was not welcome there, and nonetheless he entered. Second, we actually have both A and B. So we have 2 options: either he intended to commit an assault, or he actually did commit an assault. I would submit that we have both of those options satisfied in this instance because the testimony is that he came in and then went right up the stairs and grabbed her by the neck and shoved her back. Given that is immediately what he did when he came in, we can infer that he intended to commit assault when he entered the dwelling. Further, he did actually commit assault. So under either A or B, we have that element satisfied. Third, when defendant entered, was present in, or was leaving, was either armed with a dangerous weapon or another person was lawfully present. In this instance, there's no indication he had a weapon, but we did establish the written video was lawfully present. And so we do have probable cause to believe that each of the elements of first degree home invasion have been established. So we would move for bind over on count 1 first degree home invasion.
Thank you, Your Honor. I'll keep my argument brief. There's only 1 felony count before the court that people are seeking to find over on. I know the court is certainly well aware of the standard at this stage, which is probable cause, which is a relatively low standard. However, it is a standard that people must meet. This court is the sole determiner of credibility at this stage. I can understand the court believing that the testimony and evidence presented today will be issues for a circuit court trier of fact. However, nonetheless, Your Honor, I am asking that the court deny the people's motion for bind over and to dismiss the matter against Mr. Padilla at this time. Thank you.
Mr. Padilla went away. He didn't want his exam. Now he's posing bind over. You have something to add?
No rebuttal, Your Honor. Thank you.
Okay, we had our testimony today as part of the preliminary examination from Ms. Brittany Padilla. The burden is squarely upon the prosecution to establish just more than mere suspicion that the felony was committed and that you were the person who allegedly committed the felony. So they don't need to prove each element beyond a reasonable doubt at this stage. Again, the testimony credibility will be weighed by me, and the people's likelihood of success at trial will also be taken into consideration. Ms. Padilla testified that on or about January 15, 2026, she was present at her home at the area of 1104 Persons Court, Lansing, Michigan, Ingham County, making venue in this court appropriate. She said she was showering, getting ready for work when she heard what she believed her door to be open. She had already previously indicated that she saw the person she identified as Mr. Padilla, Mr. Joseph Padilla, who's her estranged husband, and who she already has a personal protective order out sitting outside of her home. I mean, she didn't think anything of it at that point, but she did hear the door open. She said her the door was unlocked, and that she heard Mr. Padilla coming up the stairs, that when he approached the stairs or approached her, that is, he ran towards her, grabbed her by the neck, and stated, and I quote, "I'm tired of you cheating on me, bitch." She said that a coworker appeared probably within 5 to 6 minutes after the fact. She told the coworker what happened. The defendant ran or left the home at this point. The police were called, and that both gave statements to the police. On cross-examination, it was determined that based on Ms. Padilla's testimony that Mr. Padilla was likely under the influence at the time of this alleged incident. Again, the elements of home invasion were indicated on the record by the prosecution. I think the elements are all there. The defendant entered without permission Mrs. Padilla's home. That's evident by the fact that she has a personal protective order on him. It says it doesn't matter whether the defendant got his or her body inside, but in this particular case, the testimony is that he did get his body inside. If the defendant put any part of his body in his dwelling without permission, that is enough to count as an entry. Second, that when the defendant entered the dwelling, he either intended to commit, in this particular case, an assault, or that he did commit an assault. I agree with Mr. Marchmina's assessment of the facts of this case, that if true, when Mr. Padilla entered, he both intended to and immediately ran up the stairs, grabbed her, and committed an assault. With that being stated, it says the last element is that while the defendant entered, present, and was leaving the dwelling, the following circumstances existed in section B. Another person was lawfully present, that person being Mrs. Padilla. The court is satisfied with the factual basis for the purposes of probable cause, and this will be bound over to the circuit court for a bind over date of July 29th. That's the date the circuit court's going to receive this file. It's not a date. Okay. Next court date will be a free trial. Your attorney will be made aware of that date. Do you have any questions at this time?
Want to just apologize for my.
Well, I don't say.
Who are you apologizing to?
I want to apologize for my attitude last week when you asked me about feeding the O, and I was kind of bummed out, and my mental health probably pretty much got me real bad. So
I asked you about a fee that you owe?
it's like $122. You asked me at the end of the total arraignment.
Oh, yeah, because you had another matter.
Yeah.
Oh,
I want to apologize for my.
I appreciate that. I could understand frustrations. I'm sure emotional for both parties to be here. Unfortunate for both parties to be here. So hopefully, I don't know what we did with that. I think we probably set it out maybe for a review date or something because you're in custody. So it'll get resolved. It sounds like you, at least while you're sitting there, you're taking into consideration your emotional wellness. So continue to do that. Move on with this matter, 15,000 cash surety that will continue. Any additional matters for the record?
Talking from the people.
I have nothing additional by Mr. Padilla, Your Honor. Thank you.
Thank you. You're all set. Who is it? Why did I cross them out? We didn't do that one yet. We're writing Sanders.
Yes.
Okay, Sanders can be brought up. How many witnesses do we have for Wilson?
I don't have anything.
Well, Your Honor, Wilson is kind of tricky because he's charged with CCW, but the defense has just shown me evidence that he actually had a CPL. So I think that we were going to be asking if we could kick it out one more time so I can talk to a superior about.
That doesn't sound tricky.
I want to dismiss them.
That doesn't sound tricky at all.
Well,
What's the tricky part?
the tricky part is if I dismiss it without talking to a unit chief, I'm gonna get yelled at.
Well, that's not tricky. It's just you need more time.
Yeah,
It's not tricky. It's not your fault that you don't have the authority to dismiss it, but it sounds like you have
some evidence that shows that we can't move forward.
That is correct, yes.
Okay.
If people want a couple of weeks, Judge, if my client could appear on Zoom, I think this is gonna be dismissed. He did take off work to be here. He's got proof of CPL. I want the case dismissed.
You said he took off work and I didn't hear what you said after that.
And he's got proof of his CPL. The cop never should have charged. It's no offense.
Call your witness. You got the CPO. Well, let's move forward. We can get this dismissed right now on the record.
On the record of the matter of the state of Michigan versus Jacob Wilson, 2601238. Appearance.
Ross Martin for people.
Good morning, Your Honor. William Amadeo, P 76194 for Jacob Wilson. Jacob, please state your name for Judge Simmons and her staff. Jacob Wilson.
Okay, Mr. Wilson is present. This is for carrying concealed weapon. And there was a police officer assault resistant truck, correct?
That's correct.
Okay, in your position, obviously, that your address is that you don't believe you should have been charged at all, or just for the CCW?
Should have been charged at all. And I can make a record why.
Okay, well, we'll do that in order. I just wanted to make sure. Okay. Call your witnesses.
Okay, the people call Ilya Barabanov.
I'm sorry, name mentions. That whatever's going on out here is small. We gotta stop it. Okay, that's okay. What you doing? Did we get lost? Maybe you got lost.
I'm confused. Did he get lost?
Sure.
Do we need to search and rescue?
Judge, I went to the witness room. I didn't see the prosecutor or the officer, so maybe they were at lunch or something. I don't know.
Did you see Ross? So can you read on us the Jeff song? Oh, this sounds tricky now.
Right.
Okay, so
You got lost.
I got lost. Yeah, I fell down and I hit my head on the base. So we're going to dismiss this case without prejudice, and we'll likely be reissuing with misdemeanor charges or not a CPL. We did confirm that the officer did run the gun through lane and saw that he had a CPL, but there are other misdemeanor charges associated with how the gun was being. There are other misdemeanor gun charges that we plan to issue, but we cannot proceed with CCW, and so people would like not only without prejudice.
Can I make a record?
You may.
My client was stopped for allegedly not having a turn signal at 1:30 in the morning in Lansing. This officer went to his apartment, then said he committed an R&O by not following the rules on the turn signal. Then they went to this man's vehicle and saw a gun in his car and never ran a CPL check. This was driving while black, respectfully, Your Honor. He does not deserve to have misdemeanors brought back against him. This case is a joke.
The record has been made. The case will be dismissed without prejudice. And if reissued, appropriate motions should be filed.
Will do.
Thank you. We'll get you a copy of dismissal in just a moment.
I guess I would just note that I disagree with the recitation of what happened.
And Judge, can we, in order for all his property to come back?
Well, of course, they have to give all the property back. The other thing is, where is the officer?
He's in the library.
Oh, wow.
He did check a CPL.
Well, we don't know
It
that.
wasn't
I told you to call your witnesses.
I
Could've-
spoke, okay.
He could have told me that. I don't know who to check.
When
I know
spoke
the
with him
affidavit of
and-
probable cause, affidavit of probable cause definitely said that it was the gun was lawfully registered to him. It doesn't mention anything about his CPL, but,
The police report likewise doesn't mention anything. I will make sure he knows to put in the police report that there is a CPL. He told me that he did run it through lane and that it was a CPL. And he was surprised that CCW charge.
It actually says on page 4.
he was surprised. He said, because he didn't do the affidavit of his tremor.
Judge, it says on page 4, the firearm and vehicle are registered to Jacob Wilson. I'm not sure what the officer's confusion was.
I think that's also in the affidavit of probable cause.
Yeah, it's Mr. Lee. Let's see. Mr. Austin's fine and Sanders. Sir,
How long might we be able to wait?
I'm just waiting for your attorney. I don't know where he is right now. I'm assuming he must be in someone else's courtroom. Are they having an exam?
Yeah.
I think he's running an exam in another courtroom. You were here for sentencing, sir?
Yeah, probation.
You want me to jump in, Judge? I could review the PSI real quick if that helps.
Mr. Lee, correct?
Yes.
That's what I was trying to see what's happening here. If you want to get the copy of the PSI.
Sure.
For assisting.
He's represented by the Office of Public Defender. I think confirmed they would need to file an appearance to be represented.
I'm not gonna charge or anything. I think I'm a conflict guy for them, so I don't think it's gonna be an issue.
All these do is place an appearance on the record. He wants to do pro bono work.
Yeah.
And then Mr. Austin, is running your client, correct?
Standing is.
How many witnesses? Yeah.
I anticipate 2 witnesses.
Okay. You can, well, actually, we'll wait until I do the sentencing. Should take a couple minutes. You can come up, Mr. Lee. Is that your coworker?
Yes, ma'am.
Y'all ready to go to work?
I need him, man. I need him at work,
Stuff to
man.
pay
I
off,
need him
you know.
back. Good work. Just for a break. It's good work.
Thank you. Okay, now the record in the matter of the state of Michigan versus to Toronto, Demond Lee, 26-01189.
Rob Price, unit for people.
Good morning, Your Honor. William Amadeo, P76194 for Mr. Lee. I am appearing pro bono for the Public Defender's Office. Mr. Lee, state your name.
Judge Lance of Monterey.
Okay, just my little step for sentencing today. I do have a pre-sentence report and investigation that was prepared on the 13th. Mr. Amadeo did receive a copy to go over with you. Do we need to make any corrections, updates, or deletions?
Come from the people.
From review of my client, Your Honor, no additions, deletions, or corrections.
You can make allocation.
Thank you, Judge. I just ask you to follow the recommendation. My client is waiting to go back to work. He seems to be a very hardworking individual. Apparently his boss is here. The only request I make is, I don't know if he had to report today, but if you go to work today and then contact probation, it's a normal rec. I ask you to follow it. Thank you.
Recommendation is for 9 months probation. So it looks like you, on the day of the event, got to an argument in your front yard prior to the police being called, reported that you had injured your thumb on the door during the argument and was on your way to seek medical attention, and reported that you resisted because of injury in your hand and you were bleeding. You acknowledged the incident was avoidable and should have complied with the officer's command. Did you want to add anything additional, sir?
No, ma'am.
To 6 months probation. While on probation, you have the following conditions. You're not to engage in any assaulting or threatening behavior. And you are required to maintain your job. You provide evidence of that. You don't have to bring your boss to provide us evidence.
No, it was just, we was already. We was like, oh, this is a food before you hit the road. They wasn't even gonna like that.
But I mean, if that's the best evidence you got, we'll take it.
Appreciate it.
Let's see here. It says that you have a valid
medical marijuana card, is that correct?
Yes,
I'm
ma'am.
actually not looking to orders, testing at the time, so I don't see how anything to do with this. And it says you are non-reporting probation.
And
Isabella County.
yeah, I get a sentence on the 22nd of this month. Cause I had about a violation when I got left up there.
I'm gonna order that you complete moral reclamation therapy. You have the right to request early discharge from probation once you've completed 90 days. If you don't violate within the 90 days preceding that request, you will use the court's MC 5124 form that's on the court website. This is actually your form that tells you about this, or you can get a copy of the form from your probation officer. If you complete the form, you must file a copy of that form on the probation department and on the office of the prosecutor, that is. The prosecutor's office has 14 days to respond in writing to object to any early discharge, okay? If I set it for a hearing, which is not likely, you have the right to hire an attorney to represent you for that hearing. You do not have the right to court appointed counsel, nor do you have the right to free work for Mr. Amadeo for that purpose, okay? You have any questions at this time? You'll hear from the probation department once they complete the orders. I wouldn't send you because you've already reported for orders. I wouldn't send you down right now. But it looks like the probation officer is Mr. Sumter, okay? Do you have any questions at this time? There is a $75 crime victim rights fee, $50 state minimum cost, $30 per month oversight fee for each month of probation. If you do the full 6 months of probation, your total fines and costs is $305. You will make monthly payments on that, okay? Any additional matters for the record?
Nothing for people.
Not for the fact, Sharon, thank you.
You are all set. Best wishes to you.
I appreciate it. Have a good day.
Thank you. Thank you, Mr. Amadeo.
So, yeah.
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 You got
So you expect them? There they are.
Thank you. Have a good one. And this is Mr. Sanders. Senator Michigan, this is Isaiah Sanders, 2670177. I think that's good.
Ross March, meet up for people.
Thank you, Your Honor. Good morning, Jared Austin, on behalf of Mr. Sanders, who is present with me at council table. Your Honor, before we continue, may I confer with Mr. Martinez
Yeah, absolutely.
briefly? Your Honor, Mr. Sanders just noted, what it means to note, he had inquired if you could waive his right to the preliminary examination. My understanding from conferring with people is that they wish to exercise their right to conduct a preliminary examination, but he wanted me to note that for the record, is that he is willing to waive his right to the preliminary examination. My understanding is that people wish to exercise their right.
That is correct, Your Honor. We have our complaining witness here and got it. Need to preserve the testimony. We do plan to connect with that.
Sorry, witness.
We'll cross it for you, remember?
Sequestration order is granted.
Thank you.
Well, they was getting started today. I was like, whoa, whoa, whoa. It did say that he left. It did say he left the firearm for a long. That's what that's what I was wondering. What? That's what I'm saying. You can't leave your firearm in the car alone. And the holder. And the cup holder.
Oh, come
Yeah, it is. It is. I would say, I would have said, I think in interest of justice because he was treated already. So let's just call it a wash. Yeah.
That's
You're gonna
fine.
stand and you're gonna face towards the judge. He's gonna put you under oath.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
You can have a seat, man. Make sure your ringer on your phone is off. Sorry?
Okay, sorry, I'm trying to turn it off. Okay.
Oh, okay, there's a microphone that's right in front of you. The purpose of that microphone is not because it's going to amplify or make your voice be heard in the courtroom. The microphone is only going to allow the system, the recording system, to pick up your sound. I need your voice to be loud and clear so that we can hear you in the courtroom, okay?
Okay.
Also, if there's an objection from either side, you'll stop speaking. I need to make a ruling on that objection, and then I'll tell you if you can give us that answer or not. All of your responses must be yes or no's or verbal, I should say. You can't do to yes or no questions, okay?
Okay.
State your first and last name and spell both names. Spell them, yep.
SHUUITA. Last name Rembert, REMBERT.
You can proceed, counsel.
Okay. Ms. Rumber, thank you for being here. If you need a break, take a breath, and if you want to catch something up, okay?
Yeah.
Now we're gonna hop right into it. Do you know someone named Isaiah Sanders?
Yes,
How do you know Isaiah Sanders?
we were dating.
And about how long were you two dating?
I can say probably about 2 or 3 months.
And Isaiah Sanders, you see him in the room right now.
Yes.
Could you please tell me where he's sitting and describe his clothing?
You said describe what?
Yeah, could you tell me where he's sitting and what he's wearing?
He's sitting in a red chair and he's wearing a blue jumpsuit.
The witness pointed towards the defense table, and could the record reflect that she identified the defendant?
Any objection?
Without objection.
Identifications noted.
Now we're going to talk about July 2nd, 2026. Do you remember that day?
Yes.
Was there a time that day when you were in a car with Mr. Sanders?
Yes, I was.
And where were the two of you going?
I was actually picking up my best friend from the bus station. The Greyhound drops them off on Saginaw by the Dollar Tree and I think it's called Bachi in Plaza. And we were headed there to go get him.
And did there come a point in time when you were in the car with Mr. Sanders and you came to a stoplight?
Yes, we were going down Saginaw and I pulled over to the park to make sure that my best friend was there. I didn't want to be there too early, so I won't have to sit out there and wait. And so I pulled over to call him to get basically his ETA to see where he was at. And when we pulled over to the park, that's when everything occurred.
Okay. So you are pulled over at this park. Remember which park it was?
I don't know the name of the park, but I know it's like, I don't know. I think it's a baseball stadium, like in there, like a baseball thing for the kids or something. And a pavilion. I don't know the name of it.
This park, is it a Lansing Park?
Yeah.
Okay, so then it is in the city of Lansing.
You got a
Then
yes?
Yes.
And it's in Enum County.
Yes.
Okay. And At this point in time, when you're in the car, did Mr. Sanders do anything to you physically?
Yes, when I backed up and he reversed the park, I don't know what happened, but he just grabbed my throat with both his hands and just was choking me.
Okay, so you indicate he grabbed your throat with both his hands, and when you say choking you, what do you mean by that?
I couldn't breathe.
And is that because he was squeezing your neck?
Yeah,
And for how long were you not able to breathe?
I don't know.
At any point did you become dizzy?
I couldn't talk. I was from
Okay, so you couldn't speak, you couldn't breathe.
you know,
Were you seeing stars or anything like that?
I opened my eyes and I looked at him. I looked at him in his eyes. I just didn't see him.
Now, when you say you didn't see him, what do you mean by that?
Like his eyes was black to me.
And did he say anything before he began strangling you?
You know, it was just out of nowhere. Like he knew I was pulling over to contact my best friend to see where he was at on the bus. And then next, like, I don't know what happened. He just grabbed me by the throat with both his hands and was holding on tight. And I was kicking and I was pushing and trying to fight him off. And then I asked him,
So eventually, did he cease squeezing your neck?
he just, eventually he just stopped.
Did you do anything to cause him to stop, or did he just?
No, I
stop?
just kept pushing. I was pushed, like trying to get him off my neck, but his hands were too tight gripped around it. So I was just using my feet to kick, but I'm in the car, so I can't, it wasn't much room.
And when he eventually did stop, did he say anything to you?
I asked him like, well, like, what's wrong with you? Why did you do that? And he said that we were role playing. And I asked him, what kind of role play is that? Like, what are you doing? What do you mean role playing? We were driving, I mean, you know, we were going to get my best friend in our park. Like, I didn't understand the concept.
And at this point, were you able to separate from him?
No, he didn't want to get out the car, so I tried to pull up to the gas station and ask him to go in to get me some chips or something. But he already knew that if he got out of the car, then I was just gonna pull off because I was scared. So he never did try to get out of the car, but eventually when we went to go get my best friend at the at the plaza, we went into the Dollar Tree and he went down one aisle and then I went down another aisle. And when we were separated for that little small period of time, that I just took off running out of Dollar Tree and I ran and jumped in my truck and pulled off. And he was chasing after my truck.
Okay, so just to walk through it one step at a time, the two of you went into the Dollar Tree, and then when you were able to separate, you got into your truck and you left.
Yeah, like he went down one aisle because I was trying to get away from him any way possible. I was like, when we went to the gas station, I pulled up to the gas station and I said, can you go pay for the gas? And he was like, no, you're gonna leave me. So he already knew that I was trying to get away from him because of what he did.
And when you left in your truck, did you go home?
I had to come, well, actually, when I got in my truck, I had spins around because I still had to get my best friend. So off the Greyhound. So I just moved, I parked behind, like, I think it's called Fun City. I moved all the way over there. I parked over there where the bus stop was actually gonna stop, you know, let my best friend off. I saw Isaiah walking down to like by Audie's, like that area across the street and Chick-fil-A over there. So I knew that he was away from me. So I just stayed right there and by Fun City and I was waiting on my best friend. So when my best friend got off the bus, that's when I left. And about time I left, I didn't see him. I didn't see him.
And then did you eventually go home?
Yeah, me and my best friend went to my house.
And your house, is that at 3020 Greenbelt Drive?
Yeah.
And can you tell me, you indicated it's a house, is it a single dwelling, a single family house?
Yeah.
And do you live at that house with Mr. Sanders?
No, I wasn't living, well, I lived there. He doesn't
But
reside
Mr.
there.
Sanders did not.
No,
Has Mr. Sanders ever lived there?
no, he was spending the night, you know, we were dating, he was coming over a lot.
He would occasionally spend the night, but as a guest, not someone.
Right.
And now, did there come a time Did there come a time later when you saw Mr. Sanders at your house?
Yes.
And how did he get into your house?
My window, he was breaking into my window.
When you say he broke in through your window, can you sort of describe what he did to get in through your window?
It was bent, but I fixed it to the screen because I had my window open. And I usually have a fan in there, but it wasn't a fan in there that day. So I just seen him breaking the screen of the door. I mean, of the window.
So he sort of broke through the window screen.
Yeah, it was bent, and I was just like, don't break my screen. I just told him, don't break my screen.
Okay.
And at that time, I knew I couldn't get away from him.
So did he cause damage to the screen when he was entering?
I mean, it was bent, but it was fixable.
Okay. But it was bent and it wasn't. So let me just make sure I understand. It was previously bent and then you fixed it and then you re-bent it when he was.
No, it wasn't bent at all previously.
Okay.
It was perfectly fine. He bent it as, trying to come into my window because he knew he wasn't gonna be able to come through the door.
All right, thank you for explaining that. Now, did he say anything to you about why he was in your house?
No, he wasn't. From my understanding, he knew what he did was wrong, and I didn't understand.
I'm gonna object. That calls for speculation on the part of the witness.
Sorry, I will direct the witness a little better.
Right, the objection sustained.
Yes, thank you. So anyway, after he's back in your house, and just your house, is it also in the city of Lansing?
Yeah.
And is it in Ingham County?
Yeah.
And after he is in your house, did he say anything to you?
No, he was talking to my best friend.
Was your best friend in the house with you?
Yeah.
Okay. And then did there come a time when he became angry?
Well, not at that moment. He was just hyper and he was just really, 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 really hyper and telling my best friend, like, I've been waiting to play the game with you. Let's hurry up and play the game. And my best friend told him like to calm down. Like, why are you so hyper? Like, just take it down a notch, because he was bouncing around the house saying that, like, I can't wait to play the game with you. Yeah, I've been waiting, but he was bouncing on his tippy toes. So I already knew something was wrong with him.
Okay. And did there eventually come a time when things became physical again?
Yeah, my best friend had left, so it was just me, and my cousin. No, actually, it was me and my friend and her boyfriend. And then all of a sudden, my cousin boyfriend, well, my friend boyfriend told him, let's take a ride to the store.
So your friend's boyfriend told who to take a ride to the store?
Isaiah, let's take a ride to the store, because he was acting, his action was really bouncy and super energized, so nobody understood.
So he seemed like unusually hyper.
Yes, like it was just like he was moving too fast and doing hyper bouncing around. So
your friend's boyfriend said, let's go to the store.
Yeah, let's go to the store just to take him away, because they knew. I told them.
Okay, I'm sorry. Let's just try to stay within my question. No, it's okay. That's how people usually talk, but we have rules that we need to try.
Okay.
Yep. Okay. So, how did he react when this individual asked him to go to the store?
He said no. He didn't want to go. He didn't want to go.
And at what point did it become physical again?
When they got back from the store.
Okay. So, who went to the store? Did Isaiah go to the store?
Yeah, he went to the store.
And then when they got back, at what point after he returned did it become physical?
When he spit on me.
Okay. And so he left and then he came back?
Yeah.
And after he was back, did you allow him into the house, or did you?
Well, yeah, because he was with the other person, and I thought the ride to the store was gonna calm him down. Plus, I was in the house with him, right, and I was away, so that the mission was to get him out completely. But I didn't want him to try to choke me again, or I didn't want it to escalate to anything else. So I was just trying to be as calm as possible to, like, smooth the situation over for him to just go.
Okay. And when he came back into the house, you indicated that he spit on you.
Yeah, he was, we all were in a conversation, me, my friend and her boyfriend, we were all, us three was in a conversation. And, you know, he chimed in, he just walked past me and then he turned around and he spit.
And did the spit hit you?
Yeah,
Where did it hit you?
my face.
And did anything physical happen after he spit on you?
Yeah, I punched him in his stomach.
Okay. And then what happened after you punched him?
He balled up on the floor and he was laughing. And I asked him like, why did you just spit on me? And he just got up and he was like, I don't know. I don't remember if he said that didn't hurt or that was nothing. I don't remember his words, but next thing you know, he just punched me dead in my face.
Okay,
A
so
couple
just
of times.
to make sure I'm understanding the order that's right. He spit on you in your face and then you punched him in the stomach.
Yeah.
He balled up and started laughing
Mhm.
and made some comments.
Mhm.
And then he got up and he punched you in your face.
Yeah.
And when he punched you in your face, do you remember which hand he used?
No, like he
So,
punched me multiple times, so I don't remember. He just punched me really hard in my face.
And you said he punched you multiple times?
Yeah.
Was it one punch after another?
Mm-hmm.
Is that a
That-
Yes. Sorry.
And do you have any guess of how many times he punched you in the face?
No, I do not.
And was he using a closed fist when he did that?
Yes.
And all of these punches were these to your head?
It was, well, yeah, it was to my face. I know.
So he was punching you in the face?
Mm-hmm.
Yes,
Yes, sorry, I'm sorry.
you're fine. And these punches in the head, were they painful?
Yes.
And what kind of, physically, what were you experiencing after he was done punching?
Honestly, I don't know. I was just in pain, but I was just, my adrenaline was rushing, so I was kind of like numb and shocked. So I couldn't tell you the pain, but afterwards, a few days after, I mean, the night.
So let's go back to, did he stop punching you on his own, or did something happen to cause him to stop punching?
No, he didn't stop punching me on his own. Everybody that was in the house was hitting him, like trying to get him off me. He was on me. He was holding my hair and I was holding his.
So he was holding your hair while he was punching you?
Yeah, like after he punched me a couple of times, I was holding on to him. He was holding on to me. So it was like we were locked. We were locked head to head.
And then how ultimately were you guys able to be separated?
We wasn't able to be separated. The only time we were separated was when we all of us in the house had dragged him outside because he wasn't trying to go outside. And I wasn't gonna let him go because I was scared of what he was gonna do to me.
Okay, and was there a time when anybody had to use any sort of pepper spray or anything like
Yes.
that?
My friend had to use pepper spray on him. And when she pepper sprayed him, you know, I never been pepper sprayed before, so I didn't know it goes everywhere. So my eyes was burning, my legs was burning, but I was still holding on to him because he had me. So as I was trying to open my eyes, it was burning. So I just kept my eyes closed, but I wasn't gonna let him go because I was scared. Because how am I gonna defend myself if I can't see?
And who is the person who pepper sprayed him?
My friend.
What was your friend's name?
Her name is Tawana.
Tawana, how do you spell Tawana?
I don't know how she spelled her name. I know it's T-A-W. I don't know if it's I-N-N.
Do you know Tawana's last name?
No.
And who else was present when this was happening?
Her boyfriend, but I don't know his name. Well, I don't know how to spell his name.
So how do you say his name?
Kevin.
Kevin, okay. Do you know Kevin's last name?
No.
And who else was present?
Besides my children, they were there.
Okay. And how old are your children?
17 and 11.
And what are your children's names?
Damarion Renber and DeMarquise Renber.
And was there someone named Keisha Lawler present?
Who?
Keisha Lawler.
No.
Now, moving on. So then a combination, just to make sure I understood, it was a combination of the pepper spray and everyone sort of forcing him out of the house is how it ended.
Yeah.
And at this point in time, did someone call the police?
Yeah, she did call the police.
Who is
And
she?
Tawana.
Tawana called the police?
Mhm.
And Tawana is your friend? Yes. sorry.
Yes, I'm sorry.
You're fine.
I'm sorry.
And then did the police respond?
Yes, I don't know what they were saying because I was just too busy trying to lock up everything and make sure every door in the door was locked in my house.
And do you know where he was when the police were responding?
He was out front. He was on my front porch and he was just screaming for me to open the door and that he was sorry.
And did you happen to see any of his interactions with the police?
Yes, when I went to go close my window, my room window, he jumped in my car, my truck in the driveway. And I asked the police, I said, can you get him out of my car? And the police had walked up, he was already proceeding to walk up and I don't know if he opened the door when Isaiah was in there or the door was already open. But I know I seen the police walk up and the police asked him, either what's wrong or what's going on, or are you okay? And then all I seen was Isaiah just punch the police in the face.
So you saw the defendant punch the police officer in the face, and you indicated that he got into your car?
Yeah,
And then were you speaking through the window when
Yeah,
you saw
I
the
was
police
in the
was in your
window.
car? Okay. Now, after this was done, did you have any ongoing pain in your head from being punched?
yeah.
How long did this pain last?
It was days. I had a knot in my head and scratches on my neck, and some of my hair was pulled out.
And was that from him grabbing your hair while punching you?
Yes,
And so you said did you ever seek medical attention?
no, I did not. My skin was really, the pain at that moment was honestly from the pepper spray. I didn't feel anything else at that moment besides the pepper spray. I was
So
burning.
it was later that you felt the
Yeah,
pain
it was
from
after the pepper
punching?
spray had wore off my skin, and that's when I felt the other pain.
All right, thank you so much. I think that's all the questions I have for you.
Cross examination.
Morning, Ms. Rember.
Mhm.
So this incident you were talking about in the car,
Yeah,
that was the one that happened first in kind of the order of events that day. Is that right?
yeah.
And what time of day are we talking about that would have occurred?
I don't remember the time. If I could look through my phone, I could tell you, but
Do you know if it was morning, afternoon?
no,
evening?
it was afternoon.
Okay, and you and Mr. Sanders were in a car and you were heading to the Lansing Mall, is that correct?
Well, it's across the street from the Lansing Mall, it's in the plaza.
Okay, and what is the plaza you're referring to when you say plaza?
The plaza is, I don't know what it's called, but it's like Dollar Tree, Sally's, Hibachi, Chipotle is in the plaza. I don't know what they call the plaza.
And that's all on the west side of town, is that right?
Yeah,
Around the Lansing Mall area? Okay, and that is outside of the city of Lansing, that would be crossing over into Eaton County, is that correct?
I'm guessing.
Okay, and this incident that you were talking about in the car where you said that Mr. Sanders strangled you, that's when you were stopped at a red light, am I understanding that
No,
correctly?
I have pulled over to the park for I can make sure I pulled over to the park to make sure my best friend was on his way. I didn't want to be too early and I didn't want to be late either. So I really wanted to make sure that he was there and the bus didn't make a detour or anything.
And And so you were stopped, is that around that park or pavilion that you were referencing?
Yeah, I put into the park in reverse and parked in a parking spot.
Okay, and as you sit here today, you can't recall the name of the park or pavilion?
No, because I never went there. That was my first time. I just wanted to pull over and get off the road. I didn't want to be on phone.
And you can't really narrow down or pinpoint the exact location of this park or
It's
pavilion?
right across the street from Big B. It's Harbana on one side.
You said what?
It's Big B. Okay, it's on the north side of town. It's Harbana. It's where the old famous taco used to be.
Oh, okay.
it's the
It's
famous-
off Saginaw.
Yeah, it's the Harbana.
Is
And
that
then
Oakland?
it's the Harbana, and then right across the street from Harbana is the Big B.
Were
And
you
then right-
driving down Oakland
I
at the
don't,
time?
Saginaw.
Well,
That's-
I'm just trying to figure out where this park
Is that
is.
Oakland? I don't,
Um,
okay.
was the park to your right?
Yeah, it's to my right.
Okay, so it's where the split, I believe, is of where Oakland and Saginaw.
Yeah, because the bridge is right there.
Correct.
Yeah,
Okay, I'm familiar with the park.
I don't know what it's called.
There is a baseball diamond there.
Yeah,
And that's where you said the strangulation occurred at?
yeah.
And you were parked at that time?
Yes, I was.
Okay. And who was this best friend that you were contacting?
You said, who is he?
Yes, the name of this person.
Why does that matter?
You have to answer the question, ma'am.
Okay.
Central witnesses.
His name is Bug. He wasn't there when the
Bug?
event occurred.
Did you say his name was Bug?
Yes,
Is that,
Bug, Bood.
That's his government name?
No, his government name is Kira,
you know Kiara's full name?
Kira Smith.
And after this strangulation had occurred and ended, you were still in a car with Mr. Sanders,
Yes.
is that correct?
Yeah.
Okay. And you did not call or notify the police immediately after that as related to the strangulation, is that correct?
Right.
And so at some point, you end up separated from Mr. Sanders, and then there's a passage of time before he comes to the house. You said he come in through the window, is that right?
Yes.
What type of a time period are we talking about between these two instances?
I honestly can't tell you the time period because I didn't understand how he got to my house so quick from by the Lansing Mall. Because I made it there first, and then shortly after I made it there, he made it there like 10, 15 minutes after me. So I don't know if he must have got a ride, so I don't know.
So between the time of the strangulation incident and he arrived at the window, are we talking minutes, an hour, hours?
No, it was directly after. It's like after the strangulation happened at the park. I went to get my best friend. Well, I went to the plaza and I was still around him, so I had to get away from him. And then still pick my best friend up from the bus station. I mean, from where they were dropping him off, and I went home. At that time, when I was going home, I don't know if that was like 15, 20 minutes, I'm not sure. From the plaza all the way to my house, because we didn't stop anywhere. We went right to my house. And me and my best friend went right to my house. And then like 15 minutes to 20 minutes later, I don't remember, he was at my window.
And that's, when you say you picked up your best friend, that's the same Kiara Smith that you're talking
Yeah.
about? Okay, and you picked up Kiara Smith.
Yes, I did.
And when you picked up Kiara, Mr. Sanders was no longer with you, is that right?
Yes.
And you didn't contact the police at that point about
No.
the strangulation, is that correct? Okay. And did you talk with Kiara about what had just happened between you and Mr. Sanders as related to the strangulation?
Not until we got to the house.
Okay. So you,
And I didn't tell him detail, I just told him we got into it.
but that's something you did not convey until you got back to the residence, is that right?
Right.
Okay. And So when you pick up Kira, what was your emotional state at that time? Were you acting as you normally would? Were you upset? Were you crying?
I wasn't crying. I just didn't want him to know.
And Kira did not express any type of concern or alarm when you picked up Kira, is that correct?
No, but he didn't know he didn't know anything. I didn't tell him anything.
And so now you're back to the residence, and this is when you said Mr. Sanders came in through the window, is that correct?
Mhm.
Is that a yes? And you stated that you didn't know or were unsure just a moment ago in your testimony as to the reason why he was there, is that right?
Well, yeah, I don't know why he came back.
Okay. And didn't he say something to the effect that he was there to get an HDMI cord that he had left there?
No,
Isn't that true that that's what you told the police?
I don't recall telling the police he was coming to get an HDMI cord, because why would he come get an HDMI cord when he don't have?
Well, let me ask you this. You do recall speaking to the police about this incident
Yeah.
and what occurred, is that correct?
Yes,
And you told them you were trying to be truthful and honest with them about what had happened, is that correct?
we were going, our initial thing. when
No,
we
ma'am,
were-
my question to you is as follows. You were trying to be truthful and honest with the
Yes,
police.
I was.
And you were speaking with them.
Yeah,
And you're saying you don't recall specifically what you told the police as to why Mr. Sanders was there. Is that correct?
right.
Okay, so if I showed you a copy of the statement that you gave to the police in the police report, might that help you refresh your memory as to what you told them as related to Mr. Sanders being there?
If you show me a copy, I still won't remember, because a lot of things happened that day. Me
Okay.
and we were going to get my.
Okay, thank you, ma'am. There's no further question pending. I
Okay,
just want to make it clear. So what you said was if I showed you a copy of your statement to the police, that still would not help refresh your memory as to what you would
no,
have
because a
told them.
lot of things happened that day, as I said.
Okay, and if you could wait till my questions are done, because we can't have a lot of crosstalk because we're creating a record here, okay? And you just mentioned in your direct exam a moment ago, someone at the house named Tawana, is that correct?
Yes, I did.
Okay. And is it your testimony, is it Tawana was the one that ended up using the pepper spray on Mr. Sanders?
Yes, she did.
Okay. And you were asked a moment ago by the prosecuting attorney in the direct examination about someone named Keisha Lawler. Do you recall that?
Yes, I recall.
And you indicated that you do not recognize such a name or know such a person?
Yes, that's what I said.
Okay. And is it further your testimony that you never gave the name Keisha Lawler to the police when you spoke with her?
I never gave the name Keisha Wallet to the police.
Okay. And did you tell the police that the person that in fact maced or pepper sprayed Mr. Sanders was in fact your cousin?
Right.
But you would have given them the accurate name of the person who did that, is that correct?
I would have, but.
Okay, thank you, ma'am. You answered my question. Prior to speaking to the police, had you taken anything that might have impacted your memory, such as any type of medications, pain medications, psychotropic medications?
No,
Had you taken any kind of alcohol prior to speaking to the police?
no, I didn't. No, I did not.
You stated that you declined any type of medical treatment after either one of these incidents. Is my understanding that correctly? At the time you're in the residence and you're saying Mr. Sanders is physically punching you, I want to get a clear idea, other than you and Mr. Sanders, who all was in the house at that time?
My children,
How many children?
2. My friend's boyfriend. And that's just me
Your friend's boyfriend, and
and her,
when you say her, you're referring to Tawana?
Yep.
Mr. Sanders was hitting you?
They were, my children were down the hall, but they did come.
Okay.
And, yeah, they did come.
And did either of them try to physically intervene in any way?
Yeah,
And your friend's boyfriend that was there, is it your testimony that he tried to physically intervene as well?
yes, everybody partook in getting him off.
And was Tawana and her boyfriend still on scene when the police arrived?
Yes, they were.
Did you see whether or not either one of them gave statements to the police,
Um,
from what you could tell?
they didn't give statements, but they did, well, she did, Tawana did speak to the police. They asked her to give the mace back to them, that's it.
Were you able to tell from your physical observations whether or not she did that? Or
She did,
is that something you personally observed?
yes, I did.
Okay. And stated in your testimony that I believe Mr. Sanders would sometimes stay there or spend the night there, is that correct?
Yes,
Okay. And he had permission to do that, is that right?
yes,
And was that kind of a regular occurrence?
yeah.
And Mr. Sanders came in the residence through the window. You did not call the police at that time, is that correct?
Correct.
All right, thank you. That's all the questions I have.
You got that.
Now, a couple of follow-up questions. The park where the first instance happened, is it possible that was Rudolph and Dorothy Wilson Park?
I don't
Just have no idea what it's
I don't
called.
know what that park is called at all.
Okay.
I just know it was a baseball dining thing there in Alpena Pavilion.
Okay. Now, when testifying today, are you testifying to the best of your memory as in how you remember it right now?
Yeah, like I can state what happened to me and where we were located at. Time wise, I can't give you, like, I can't direct at the time.
But
Unless,
the best, you're giving us as best as you remember it right now.
yeah, I mean, it was so much that happened that day.
Okay. Now, how long after everything happened did you speak to the police?
Like, speak to them after the event, or
Yes.
they were there that night, and then
Was it within an hour of their arrival? that you
oh
spoke
no,
with them?
I spoke with them. They came right away.
And did you speak with them shortly after they came?
Yeah, after they got him down and got him in a police car, I spoke with them right away on the phone.
And so was this shortly after you had been both maced and punched in the head?
Yeah, it was like literally, I don't know, I could say probably, I don't know. They came quick right
Okay.
after the incident, right after.
I think that's all the follow-up I have. Thank you so much.
Thank you, ma'am. You may be excused.
Do you
Call your
want me
next-
to go home? And
Thank you.
also allow you to stay and watch if you want.
Okay.
Call your next witness.
The people will call Ilya Barbin.
Barbara knocks on both of these, huh? Barbara knocks on both of these phones. Yeah. That's not coincidence. Oh.
solemnly swear or affirm the testimony you're going to give is the truth and the whole truth on the penalty of perjury?
I do.
You can have a seat. You can say your first and last name, spell both.
Ilya Barabanov, Ilya, last name Barabanov.
Dr. C. Counselor.
Officer, how are you employed?
Employed as a police officer at City of Lansing,
And how long have you been so employed?
approximately 4.5 years.
What is your role as a police officer in the city of Lansing?
Road patrol,
And what does that entail?
patrolling City of Lansing, traffic stops, responding to calls for service.
And did you, on July 2nd of 2026, early morning hours, were you working in that capacity?
Yes, sir.
Did you respond to a call that took you to 3020 Greenbelt Drive?
Yes, sir.
And is that location in the city of Lansing, County of Hingham?
Yes, sir.
What was the nature of this call?
Troublesome subject, sir.
And when you arrived, can you tell me what you saw when you first arrived?
I observed the subject that was describing the call, sitting in porch of the dispatch address. As I began approaching, the subject then went to the car that was parked in the driveway and got inside of the driver's seat. At this time, I did not know what was going on or the whole details of the incident.
So you arrived and someone was on the porch and that person then got into the driver's seat of the car.
Yes, sir.
And the person who was on the porch and got into the driver's seat, do you see him in the courtroom right now?
Yes, sir.
Could you please tell me where he's sitting and describe his clothing?
Sitting next to, I'm assuming that's attorney, wearing dark colored shirt.
The witness pointed towards the defense table and said the record reflect he identified the defendant.
Any objection?
No objection.
And after you saw him get into the car, did anybody say anything to you?
Yeah, as I approached the car, the door was still open as he was sitting inside, and then a female voice from inside the house advised to get him out of her car.
So someone who was inside the house, a woman told you, asked you to get the defendant out of her car.
Yes, sir.
And then did you need to approach the car?
I approached the car, yes.
And when you arrived at the car, was the door open or closed?
Still open.
And did you say anything to the defendant?
I advised the subject to step out of the car,
And what did he do?
tried to close the driver's door.
And what did you do when he tried to close the driver's door?
I put my left hand on the driver's door to keep it open.
And after you put your hand on the door to keep it open, what did the defendant do?
Just came out and attacked me, punched me in the face twice.
So he came out of the car and punched you in the face twice.
Yes, sir.
Was this with an open hand or closed fist?
Could not tell you, but I know that I saw my blood out of my mouth.
So I assume it was flying out of your mouth. Did he hit you in the mouth?
Yes, sir.
And did he immediately stand up and start hitting you in the face?
Yes, sir.
And then at this point in time, I assume you tried to take him into custody.
Fight started, yes.
Okay. And when you approached the car, were you wearing a police uniform?
Yes, sir.
And to the best of your recollection, can you remember sort of what happened when this fight started, when this was happening?
A lot of punches been thrown. Eventually, we got down to the ground to where I got on top of the subject. He said me on the ground to which point I knew I was bleeding. So I got on the radio to advise dispatch that I was in the fight. During that time, I felt a little sharp pain in my hand, tried to pull it out, had a little difficulty, and I noticed that I got bit.
Okay, and so you got bit, was the defendant who bit you?
Yes.
Where on your hand was the bite?
Palm, right hand.
Okay. And I see you have a mark on your hand. Is that from this incident?
Yes.
Okay. And when he bit your hand, were you wearing anything on your hand?
I was wearing a latex glove.
Okay. And despite wearing this glove, was any, I mean, obviously there's a mark, what kind of injury did it cause on your hand?
It punctured through the glove and then through my skin. Kind of dragged it out a little bit, if that makes sense. That's you.
For the record, I sneezed before the witness said bless you.
The record.
That'd be very confusing in a transcript, just out of nowhere, bless you.
Sorry.
Anyway, at this point, did anyone come to assist you in subduing him, or were we able to gain
No, I
control of the
stood by
situation?
myself and then an officer arrived on scene. Upon his arrival, then we put him in handcuffs.
And after he was in handcuffs, were you still bleeding?
Yes, sir.
Where were you bleeding?
Mouth, majority was a mouth, the lower of my vest, and then my hand.
So your hand was bleeding, but more so your mouth.
Yeah.
How long were you bleeding?
From what I recall, about 5 days, my arm was still bleeding, or my hand, but.
So like there was still blood from your hand for 5 days?
Yeah, I had to change out bandages.
And how long was your mouth?
It was done by the end of the night.
So, okay. There are units of time within days.
A few hours.
Okay, a few hours. Did you seek medical attention?
Yes, sir.
Where did you go for medical attention?
I got transported to Spirit Hospital by LFD.
And how long were you at Sparrow Hospital?
A couple of hours.
What sort of treatment did you receive at Sparrow Hospital?
Blood draw, testing my blood, cleaning up the wound,
And did they like bandage your hand, anything like that?
yes, sir.
And was your mouth still bleeding when you got to the hospital?
Yes.
I have no further questions. Thank you.
Cross-examination.
Morning, officer.
Morning.
Well, were you the first officer to arrive on scene?
Yes, sir.
And when you arrived, were you alone or with someone?
Hello.
And you were responding to the female voice that you heard about, you said was Mr. Sanders and a car in the driveway. Is that correct?
Yes, sir.
Okay. And you were attempting, or was your goal to, was it to extract him from the car at that time?
Asked him to get out of the car. Yes, sir.
Okay. And what was your goal in your head at that point? Were you there to detain him for further investigation? Were you there to arrest him or just to speak with him or what?
Originally, from what I recall reading the call notes, I thought he might have been the victim.
Oh.
That's where I
And
got caught off guard.
what was it that led you to believe that?
From what I remember, I read the notes that he got maced.
Okay.
And I just went off of that.
And so when you were encountering him at the car, you did not view him in your mind at that point as a suspect or the potential perpetrator of a crime?
I didn't even know what we had at the time.
Okay. And during this kind of physical scuffle that you were talking about, and that was just you and Mr. Sanders?
Yes, sir.
Okay. And at any point, did any other officers arrive on scene while that was ongoing or occurring?
One officer, that's towards the end, yes, sir.
And who was that officer, if you recall?
Tyson Graham Tyson.
And did he do anything to attempt to assist in any way with this?
He assisted me in placing him in the handcuffs.
Oh. And did you immediately go to the hospital after that, or did you?
Yes,
Okay.
LFD was there within shortly, a couple of minutes. Their station's down the road.
And so from what you have described to us here today, is that pretty much the extent of your involvement in this situation?
Yes, sir.
And you did not stay on scene or speak to any other potential witnesses or anything like that?
No, sir.
You did not transport Mr. Sanders into custody?
No, sir.
And it sounds like you went to the hospital and you were discharged the same day, is that correct?
Yes, sir, but I was placed on injury leave for approximately
You said for how long?
1 week. Yeah.
And was that at the request of the doctor? Was that some kind of department policy? Is that something you asked for or?
Not sure. I think it's because since I was transported to an emergency facility, I think we have to go see occupational health before we're cleared for full duty. Not my knowledge.
And were you given any type of clearance as to whether or not you could or could not go back to work after you left the hospital that night or day?
Not that they know.
They never said one way or the other.
No, we have to go see occupational health. They're the one charged for that.
And is that something that you did?
Yes, sir.
When was that done in relation to your visit to the hospital?
First appointment was on Monday. I need to count, know the exact date. Last week. And then second appointment was on Thursday. Same week.
How many days after this incident was your first appointment with occupational health?
I have to look at the calendar. I can't do that.
Sure. And was that just because it took a while for you to get scheduled to do that, or?
They don't work on the weekends.
Okay,
They work July weekend.
okay, understood. And did this require any type of follow-up medical care? Did you have any additional doctor's appointments, physical therapy, anything like that?
No, I got 2 shots. I don't remember what they were. No
Was that-
one was had me. The other
Was
one.
that the same day at the hospital?
No, that was the follow-up appointments, occupational health.
Okay. Other than what you've described, were you prescribed any type of medications as related to any treatment for any of these injuries that you've talked about?
I was prescribed a medication, could not tell you what it was.
And did you actually see the female, the one you were talking about, that voiced to you about Mr. Sanders being in the vehicle, or did you just hear the voice? Can you recall?
Could not recall.
Do you recall seeing anyone else on scene, either outside of the residence or in the driveway, other than, of course, Mr. Sanders?
I do know somebody was outside the residence during the fight, but due to being punched twice in the face, I could not see it.
Can you recall whether or not that person was an adult or a teenager? Do you know if that person was a male or female? Was that person doing anything other than just standing there observing?
He asked me if I was okay.
I think it's all the questions I have.
No redirect.
Thank you, officer. You may be excused.
People rest.
Please defend witness.
My bad, officer. I don't remember none of that. My
Well,
bad.
don't say.
Say it, say it.
Yes, I'm gonna take it now.
I appreciate it. Don't remember, that's my bad.
Please. Don't say anything. No proofs to present, Your Honor. We'll rely on the evidence presented.
Argument.
Okay, now, obviously, Mr. Sanders wanted to waive this exam. It's a good thing that he didn't, because we're not going to be able to proceed on the serious charge. Nevertheless, we still have charges that will support 25-year minimum super habitual offender, as it's colloquially referred to. So we have count 1, first degree home invasion. Obviously, we wound up with 2 separate entries. So we had the breaking and entering, and then we had an assault therein, but there was a separate time when he left and then came back. So I don't believe that we can proceed on the first degree home invasion. So people will need to dismiss count 1. Now moving on to count 2. Assault with intent to be great bodily harm, less than murder or by strangulation. I'll just refer to this as strangulation, because that's how this one is charged. That's what the evidence supported. The jury instruction for that is 17.35. Get that pulled up. First, the defendant committed a battery on Chiquita Rember. Pretty much speaks for itself. This is in respect to the strangulation next to what I think we were able to deduce, even if she didn't know the name, was R&D Wilson Park over in the city of Lansing, sort of where Oakland and Saginaw become one. We, of course, she described him putting her hands around her neck suddenly and abruptly and violently. This is clearly a battery, intentional. it would be very hard to accidentally put your hand around someone's neck and squeeze. And of course, afterwards, the defendant apparently suggested, well, this was role play, further indicating that it was intentional. Third, that it was committed by strangulation or suffocation, which means intentionally impeding the normal circulation of blood or breathing. The witness indicated that she couldn't breathe and that she could not even speak as a result of the pressure being applied by the defendant's hands. And so we do have probable cause to find over on count 2. Now, count 3 is domestic violence third offense, and the instruction for domestic violence is 17.2a. Now, of course, this is ordinary domestic violence, not aggravated domestic violence. And this is in regards to the car incident once again. As noted, we established the elements of battery as discussed in the strangulation count. As far as the domestic relationship count, they did have a dating relationship at that time. And so I would respectfully request find over on that was count 3, domestic violence third offense. And then count 4, we have a second count of domestic violence third offense. And this one is referring to what happened in the house, which began with the spitting and then continued with the punching and with the pulling on her hair. So all of that together, in theory, we could try to play a little dirty and split that up into like 5 different DV thirds. We're not going to do that. So we have because there are 2 distinct acts, I do believe it is appropriate to have 2 distinct counts of DV third offense. Now moving on to count 5, we have assaulting, resisting, obstructing a police officer, causing injury. And that will take us to instruction 13.1. Now, it's not very often that obviously it's assaulting, battering, wounding, resisting, obstructing, opposing, or endangering a police officer. It's not very often that we go to the assaulting part there. I mean, this is very straightforward. I don't really need to parse out the elements. We have a police officer who is in his police uniform, who this defendant just out of the blue started punching in the face. And then when they were on the ground, hit his hand. Now getting into the injury, this would be parentheses 7, there's a few different combinations in this. Bodily injury requiring medical attention or medical care. It sounds like he was bleeding from both the mouth and hand for quite a while. The bleeding from the mouth went on for a few hours. The bleeding from the hand, while not as severe, was sort of an ongoing thing for a few days. And he did need to go to the hospital and was placed on a sort of injury leave with the police. So we do clearly have the requirements for the injury. You know, we're of course not seeking serious impairment of the body function. We're going under just a normal injury. So I'm going to request find over on count 5. Now the people are going to be seeking to add 2 counts. We're going to request an added count 6, assault with intent to great bodily harm less than murder. And that will take us to instruction.
So you say you add any counts?
Yes, we're seeking to add a count 6.
Assault with intent to do
Great
great bodily
bodily
harm less
harm,
than murder.
17.7. It's something that I think it's so silly that great bodily harm and strangulation are in the same statute, even though they're different crimes. But we have different jury instructions or different crimes. Just because the penalty is the same doesn't mean they should be the same statute. But I work here, not in the building across the street. Anyway, I mean, ultimately, these elements are all they're a little redundant. I'll just go through them. First, the defendant. I'll do 1 and 3 together. So I'll start with second. At the time of the assault, the defendant had the ability to cause an injury, at least believe he had the ability. This is in reference to when things really popped off at the house, when he started repeatedly punching her in the head, was grabbing her hair while punching her in the head, and could not be separated until Mace was involved and other people jumped in. So we certainly had the ability to cause an injury. And then 1 and 3, we have tried to physically injure and intended to cause great bodily harm. We don't have evidence.
I'm sorry?
Oh,
Oh, okay.
We don't have evidence that great bodily harm necessarily occurred, but we just need the intent to cause great bodily harm. And there are 2 ways that I would suggest we can infer the intent both to cause an injury and to cause great bodily harm. One way is that he was punching her in the head, and there is case law supporting the notion that you can infer the intent to cause great bodily harm based on where a person's being hit. Second, he was repeatedly punching her at one point, holding her hair, possibly to restrain her in some way while punching her. And then third, the fact that he did not relent until several people and pepper spray had to get involved to separate the two of them. It sounds as though he would have just kept going and going and going had there not been other factors intervening to prevent it. So I do believe that we can infer the intent to cause great bodily harm. And so I request find over on an added count 6. And then finally, the people are going to seek and add a count 7, entry without permission. A 90-day misdemeanor is probably, it's a drop in the bucket compared to these D-grade felonies that will come with a possible 25-year minimum, but it is a crime that the evidence supported. I will seek to add it, and that is instruction 25.4. I mean, this is pretty simple. It's from him bending the window. It is misdemeanor.
You don't need to address why.
Well, my understanding was that because it was not previously charged, but I mean, regardless, the evidence plainly supported it. So we're going to seek to add count 7 entry without permission. So thank you.
Awesome.
Thank you, Your Honor. Kind of work my way backwards a little bit. The bulk of my argument is going to be as it relates to addressing the assault charges. I would concede, I think certainly the strongest of the charges that the people have asserted against Mr. Sanders is the R&O causing injury. So I'm not going to belabor an elongated argument on that.
You think that one's the strongest?
That is my opinion, Your Honor. Yes.
Oh, is that because you mean that based on the evidence, you mean like the more serious of the crime?
Based on the evidence that was
Oh,
presented.
okay.
I'm arguing from a probable cause standpoint is what I meant by that.
Got it. I'm just trying to understand what you were meaning when you say that's the strongest. You're saying based on the evidence, you believe that I get it now. I'm just trying to make sure you're not saying that was the most serious. Sure.
No, strongest in terms of the evidence that was presented.
Sounds good.
So I'm going to leave that at the discretion of the court. As it relates to the other assault counts, Your Honor, I am going to be opposing those. Starting first with the strangulation count in the vehicle. I think some things to point out about that, and overall about just the demeanor, and I think the testimony that I believe reflects on the credibility or lack thereof of Ms. Rimberg. First of all, I don't think was very forthcoming in a lot of her testimony here today. She did not want to give up names of particular witnesses who could verify or not verify some of the things that she was asserting here today in her testimony. At one point during her testimony, she even stated that her memory could not be refreshed on what she told the police by looking at a copy of the police report summarizing what she told the police. It wasn't, I don't know, I'll look at it and see. It said, she said, no, I could look at that, I could read that, and that would not refresh my memory on what I told the police. I think it's worth noting and pointing out in the direct questioning of Ms. Rimberg by the people, the name Keisha Lawler come up. And she stated that she did not recognize that name. That is not a name that she gave to the police. She said as much during my questioning of her on cross-examination. Now, it wasn't fully fleshed out. We didn't have the officer here who spoke to Ms. Rimberg, but I certainly think it is a reasonable conclusion that the only reason why the people would be asking that question and seemingly surprised by that, I think the reasonable inference is because that was a name that she gave to the police, and now she is seemingly telling us not only something different, but saying she has no idea who that person is. She has no recognition of that particular name. And
Well, is it
certainly,
possible that the police got the name wrong?
I suppose in almost anything is possible, Your Honor, but I think this
Well, we're not
isn't
talking
a-
about unicorns here. Police get names wrong all the time.
I think though, in this instance, Your Honor,
For your client just said she made it up.
well, and he's not testifying and he's
Right.
not making argument, but what I'm saying is, Your Honor, if I think that could be maybe more believable or more understandable if perhaps the names were similar and they perhaps misheard or made some kind of scrivener's error in writing that down. But
Right.
I think they're basing this on, I don't think it's an unreasonable argument to say based upon common sense and experience here, officers refer to their notes as a body worn camera or both when crafting these reports, and to just put down a name that bears no semblance at all whatsoever to the name or the names she gave us here today. I think it's highly unlikely that the police either just made that up or completely got that wrong to that extent.
I can't say that it's highly unlikely, because in this year alone, I've had a police officer get there under oath and tell me something completely contrary to what happened on her body cam. So that's what I'm saying, isn't it possible?
It is certainly possible to the extent that nearly anything is possible.
Yeah.
I understand the court's comments. Nonetheless, that is my argument. And she certainly never saw fit to either contact the police or contact help after the strangulation in the car supposedly occurred. Admittedly, when she was separated from Mr. Sanders. So she had the opportunity to do that. He wasn't there. So she had the opportunity where she was not with him, where she could be safe. She met up with her friend who, again, either her or her friend didn't contact law enforcement at that time. She
You
did
talking
not
about the
direct-
one that they were picking up, that friend?
Correct.
Okay.
And
To which she alleged she didn't want the friend to know. I'll agree with you, Mr. Austin, that the whole story is very weird. Doesn't mean it didn't happen, but it's a strange story.
it is certainly that at a minimum, and I would make even more inferences on that other than strange. But nonetheless, I understand the court's comments. But again, I think that is important for the court to assess the credibility of Ms. Rimbert, as the court is tasked with that position to do. Per Anderson, the court is the sole determiner of credibility at this stage. But also, I think it's worth noting, let's assume that she didn't want her friend to know, for whatever reason, that such an assault had occurred. I think it's also even more unlikely that she would not bear any type of anything from her physical appearance or her emotional state at the time that would signify to her friend that something was wrong or something had just happened, which she denied that nothing was of the sort, that her friend did not express any type of alarm or concern. So I'm asking the court to view all that in its totality and deny the people's motion for bind over. I don't believe the repeated strikes to the face of the people have alleged and asked for an additional count of great bodily harm. I don't believe that would rise to that level, assuming that's true, and assuming that the court believes on even a probable cause determination that occurred. That may be another count of domestic assault, but I don't think that would rise to the level of great bodily harm, less than murder, and the entry without permission that is a 90-day misdemeanor that was not originally charged. So I think the court does have to make some type of finding based upon that. I would just add that according to the testimony of Ms. Rimbert, and I think the reason why the people dismissed the home invasion count is because the testimony is that he regularly stayed over there, had permission to do so. She certainly did not expel him or ask him to leave or call the police when she says that he started to enter through the window. Thank you.
Any more arguments?
Just I would want to just address, respond to some of the arguments regarding Ms. Rumbert's credibility. There are a couple points I would make. Well, first off, I just think that her demeanor and her disposition and just the anxiety that she clearly was experiencing, it just came off as someone who was being truthful and who was frightened by this situation and living something that was traumatic. But more specifically, I think it's not surprising that she was reluctant to provide names of other people who were there. People frequently don't want to drag their friends into these situations with the police and with the courts. And
You don't gotta explain that to me. I'm from the hood. I know hood code.
you know, I think that if someone showed up, you know, cop shows up at front door with a subpoena because Chiquita name dropped, and that might go over well. Now, the defendant, of course, is indicating audibly right now that that's not true. As far as refreshing memory with the police report, she didn't write the report, so I don't think it is outrageous for her to say, I didn't even write that. Why would someone else is writing refresh my memory? I remember it right now. And I think I would note that us asking her a question about someone named Keisha, that's not evidence. Our questions are not evidence. The court needs to make its decisions based on the record. So while the reality is, yes, we got this Keisha from somewhere, that is not evidence. The evidence we have is her saying, I don't know someone named Keisha. And finally, I think that it is worth noting that to the extent that our two witnesses today perceived the same event, their testimony was very much alike. Ms. Rembert described looking out the window and seeing the defendant in her car, yelling out to the police, he's in my car, watching the police go up to the car and watching the defendant start punching the police officer. And then, of course, Officer Barmadoff, whose name I can never quite pronounce just right, described getting out of the car, seeing the defendant get into the car, and then a woman yelling, he's in my car, and then walking up there and getting punched in the face. So I do think that, I mean, those two are clearly not hanging out in their story straight. They both are remembering it independently and are lining up a lot. So I do think that on the whole speaks to her. Thank you.
Okay, today was the date that was set for preliminary examination. The burden is the responsibility of the prosecution. At this point, they need to establish sufficient probable cause that the felonies that you've been charged with were committed, and then sufficient probable cause that you were the person who committed the crime or the felonies that are alleged. This is not trial. We don't have to prove each other beyond a reasonable doubt. The burden of probable cause is just more than mere suspicion. So it's not a very high burden. But the court is, as your attorney has said, the sole determiner of any credibility issues. And I also will weigh the people's likelihood of success if this were to go to trial. We did have testimony today from a Shaquita Renberg. She testified that on or about July 2nd, 2026, she had been in a dating relationship with the person she identified in the court today as Mr. Isaiah Sanders, that they were in the vehicle together. And they were going to pick up the person she identified as originally as her best friend from a bus station or bus drop off, that she had pulled over to a park, which the court would take judicial notice of the area of the park. She did describe after being questioned that the park is right on the right side of Oakland Ave, right where the road splits from Saginaw and Oakland. And as questioned by the prosecutor, that is in fact Dorothy Wilson Park, and there is a baseball diamond there. So the park she described, the court will take notes, was that park that is in the city of Lansing, Erie County, state of Michigan. That makes venue in this court appropriate. She stated that as she pulled over, out of nowhere, the defendant grabbed her throat with both hands, squeezing her by the neck. She said she couldn't talk, she couldn't speak, she couldn't breathe. She said she looked in his eyes and they were all black to her. She began trying to kick, but was limited in space because she's in the vehicle, and pushing, trying to fight him off. Once the alleged strangulation stopped, she asked him, you know, what are you doing? Why did you do that? And he said, we were role playing. So she didn't understand the concept. She stated that she wanted to try to separate from the defendant, but that she believed he understood that she was trying to separate from him. So she pulled into a gas station and asked him to go and pay for the gas, to which he declined. He said, you will leave me if I do that. And then she stated that they ended up going into a Dollar Tree which I believe she stated was in the plaza. The plaza, she identified stores that was consistent with this plaza in the location across from the Lansing Mall area. That would be in Lansing, Eaton County, but within a 1 mile radius of this jurisdiction, still making it appropriate in this court. She stated that while she was in the Dollar Tree, that they eventually went down separate aisles, to which she took that opportunity to, she said, run back to her vehicle, and he chased after her truck as she pulled off. She stated she then went to her home, 3020 Greenbelt Drive. That is in the city of Lansing, Ingham County, state of Michigan. Again, making venue appropriate in this court. She said as she was there for a short period of time, that she had her window open. Typically, she keeps a fan in there, but the fan was not there, that the defendant broke or bent her screen and entered the home. She at this point is there with the person she identifies as her best friend, and that the defendant appeared to be acting abnormal or extremely hyper or energetic, and wanted to play some video game that the friend, I believe at this point is now alerted to possibly what happened, or maybe not. It's unclear when she told the friend about the alleged incident. She did testify that she did not want the friend to know about this alleged strangulation situation in the vehicle, but that the friend noticed the hyper energy and tried to get the defendant to go take a ride with him to the store. And to which the defendant originally said no, but then eventually must have gone. And then upon return from this ride, the defendant out of nowhere spit on the victim, or the alleged victim, Miss Rembert, while he's walking past. She said she was in response to him spitting on her, punched him, to which he laughed and then began to punch her back repeatedly. She said while holding onto her hair, a tussle ensues, and she says they both were locked in by holding each other's hair. And the friends that were there at this point, there's additional friends there, as well as she says her children, tried to separate the two from this lock-in of pulling each other's hair, and that one friend deployed some pepper spray, and another friend, which said Tawana, called the police. The police arrived, and the police, let me back up. As a result of this alleged altercation, the witness stated she suffered a knot to her head, I believe, scratches in her neck, and some of her hair was pulled out. She stated, well, we then had Officer Barbana. Can you repeat his name?
Barbanoff.
Barbanoff. Barbanoff. I think it's Barbanoff. Okay, I just read his name. Barbanoff, from the Lansing Police Department, who reported to the scene after being called by the friend Tawana. He stated he observed the subject on the porch. That subject is the person he identified in the report today as Mr. Isaiah Sanders. He said that he then observed the person leave the porch and go and get into the driver's seat of the vehicle, and that the alleged victim is yelling to the police to get that person or get the subject out of her vehicle. The officer attempted to approach the vehicle and to get the defendant out of the vehicle. He said that the defendant tried to close the door on him, and then once the defendant was out, he punched the officer twice. The officer reported to sustaining some injuries or bleeding, and was on injured release for at least 1 weekend. Count one was originally charged as home invasion first degree. The people are moving to dismiss that based on the testimony of assuming, because the defendant, although was alleged to have broke through the window by breaking the screen to enter, he then left again with the friend and came back. And that's the concept for the.
That is correct, yes.
Okay, so count one is dismissed. Assault with intent to great bodily harm less than make murder or by strangulation, and the prosecution has gone over the jury instructions or the elements for that. And this is where I say that this matter is indeed strange. I don't say that it's strange because I believe, or disbelieve, I should say, Ms. Lindbergh's testimony. Ms. Lindbergh, I think, made it clear that there's things that she probably doesn't remember. She said that on the record. And if this scene of events is in fact true as she displayed or portrayed them, that would be a traumatic experience. If you're driving in a vehicle with someone you've been dating for 2 or 3 months and then out of nowhere, they start strangling you and you can't breathe, that's traumatic. Why she did not or would not have called the police, then the world will never know. I'm not a psychologist, and I can't get into the mind of why people don't do or react the way we believe they should react. If I were a psychologist, and this would be the greatest case to be a psychologist on, because I could not only ascertain why Ms. Lindbergh would not have called the police either then or when she got home or when he was breaking into her window, but I could also get into the mind of potentially Mr. Isaiah, because I want to understand, if true, what was he on? If he's driving in the car with his girlfriend, he randomly decides he's going to strangle her, and say it was role play, and then go to the home to which he supposedly is extremely hyper and acting very weird to the point where the friend is trying to get him out the house to calm him down. And then when the police arrive, he assaults, he punches allegedly a police officer twice. To which, and the court can take into consideration all this, the facts and circumstances surrounding this hearing. A fact and circumstance surrounding this hearing is 2 things your client has blurted out. One of them was an apology. He doesn't remember if it even happened himself. Was he under the influence of something? Did he have a mental break? Does he have some issue with his chemical that was imbalanced and he can't control himself and now he can't remember? I don't know. But if I were to believe what you said was the strongest case in your opinion, which is that he assaulted this officer who's reporting to the scene, then I absolutely can believe that he would strangle someone out of nowhere because he's out of control. So I think that there's more than mere suspicion to support count 2 of assault with intent to do great bodily harm, less than murder or by strangulation, because although she used the word choke, we know that she means strangulation when he placed both hands around her neck and squeezed and she was unable to breathe. So count 2 will be bound over. Count 4, domestic violence, 3rd offense notice, because they were in a dating relationship at the time of this alleged incident, and that at the time he did assault her while they were in the area at or near, I believe this took place again at the Dorothy Wilson Park, that he did assault her during that time.
I'm sorry, you said count, where do you mean count 3?
What do you mean?
You went count.
Oh, I skipped count 3. Assault with intent to do great, domestic violence counts 3, correct, is the one at Oakland Ave and Durant Park, which would have been the Dorothy Wilson Park. You were correct. Count 4, domestic violence. I believe there's sufficient evidence as to that because, again, the testimony of the incidents that occurred in the home, the spitting on her allegedly at 3020 Greenbelt Drive, and then when she responded with a punch, which would have seemingly been in self-defense to the spitting. He then punches her repeatedly in the head. And then the testimony of the officer of the assault with the assault resisting obstruct as to count 5, that will also be found over. The people are asking to add a count 6 of assault with intent to do great bodily harm based on the assault at the home 3020 Greenbelt because of the repeated nature of the blows to her head, which she says she doesn't even remember how many blows it was. but then also pulling her hair. Of course, we don't need injury, but she alleged to have sustained injury because she said there was a knot on her head as well as her hair had been pulled out and she had scratches on her neck. I will grant the request for added count 6 that will be bound over to the circuit court. The people are asking for a count 7 entry without permission because the defendant allegedly through the testimony of the witness broke or bent the screen door or screen to the window that is and entered the home without her permission. That is a misdemeanor. So the court doesn't need to deal with probable cause. So counts 2 through 7 will be bound over to the circuit court for bind over date July 29th with the notice of intent to seek sentence as a violent fourth habitual offense noted under MCL 769.121A. Your bind over date is the date the circuit court's receiving this file. It's not a court date for you, okay, sir? Please quiet now. Your next court date will be a free trial. Your attorney will be made aware of that date and he'll be in contact with you. Do you have any questions at this time? Any additional matters for the record?
Your Honor, just one brief point of clarification. As relates to counts 2 and 3, there's a specific location in the complaint on that of 2026 Oakland Duran Street. And I don't think we were never able to flesh out from the witness a more precise address. And certainly I don't think testimony came out that specifically. I know the court has found bound over and it's within the jurisdiction of the court, but is the language in counts 2 and 3 as it relates to the location going to be amended in some way to more accurately reflect the testimony?
I believe that the address and the complaint is accurate because where she described was the park on the west or on the right-hand side of Oakland Ave, right across from where the former famous taco was, right at the split of Saginaw and Oakland, right before you get to the bridge, and that there is a baseball diamond right there. Very specific description. And when the prosecution asked if she knew that whether or not that was the Dorothy Wilson Park, she wasn't sure of the name of the park. The court is aware that that is the name of the park. So we did find that the venue is appropriate. I don't believe that the complaint needs to be amended because that is the address to that one.
I have Google Maps up and it looks like it's right next to Oakland and Durant.
Yeah, that's the address for that one.
That's all I had, Your Honor. Thank you. I have nothing additional on behalf of Mr. Sanders at this time.
No problem. Bond will continue as well as the no contact order. You're all set.
Thank you.
The Miss Maycomber on Vivian Simmons.
You said Ms. Maycomer's in the last one.
Yeah.
Okay, on the record in the matter of Davion Simpson 26-01441. Candace, please.
Good morning, Your Honor. Natalie Maycomber on behalf, or good afternoon, Natalie Maycomber on behalf of the people.
Morning, Your Honor. Ronald Berry, appearing on behalf of the Davion Simpson, who is standing to my right.
Okay, this is a sorry. Thank you. This is a preliminary examination today for armed robbery project. Are we ready to proceed?
Yes, Your Honor. I understand that both parties will be unconditionally waiving the right to hold a preliminary examination in this matter. We ask that case be bound over on the charges and complaint. There is a potential resolution that the parties would like to state on the record for the court.
Yes.
The negotiations that are happening right now is a potential plea to an added count 3 of accessory after the fact. It should be noted that the defendant is currently appears to be eligible for HIDA. There would be no objection to that if he is eligible. The parties are still negotiating that ultimate plea and sentence agreement, which would include the dismissal of counts 1 and 2.
Mr. Berry.
That is completely accurate. That's part of the exchange from the examination, and then the circuit court should we come to a final agreement. And additionally, we have an agreement regarding bond as well, which I'm sure Ms. Smith understands too.
Yes. Right.
Never looks at me, so we just control. There. Yeah. Okay, so Mr. Simpson, you understand that you are being charged with felonies in this file, correct?
Yes, ma'am.
And you understand that you have the right in this felony matter to proceed to preliminary examination
Yes, ma'am.
and the right to require the prosecution establish sufficient probable cause for the felony you're being charged with was committed, and then sufficient probable cause to charge you as the person who committed the felony. You understand that?
Yes, ma'am.
Are you willing to unconditionally waive your exam?
Yes, ma'am.
That means you would waive it and there's no promises or conditions that you're waiving it on. Once you waive it too, it's gone. You can't change your mind. You understand that?
Yes, ma'am.
Okay, no one's threatening you to get you to waive your exam, correct?
No, ma'am.
There's not been any promises stated, that's not been stated on the record to get you to waive your exam.
No, Your Honor.
The bind over date is July 29th. That's the date the circuit court is receiving this file. It is not a court date for you, Mr. Simpson, okay?
Yes, ma'am.
The next court date for you will be a pretrial. It will be set after the 29th, and your attorney will be made aware of that.
Yes, ma'am.
Have any questions so far?
No, ma'am.
He has no prior criminal history, correct?
That is correct.
You want to address bond.
We have an agreement, so I guess I.
There's no such thing as an agreement about
Well,
bond.
we have an agreed position to recommend to the court.
You want to address bond?
I believe it's, I will say people have no objection if the court were to reduce this to a PR bond as long as the GPS tether would remain in place. I understand the court has probable cause affidavit in a file, but just as a brief overview, This defendant is a co-defendant in a 3 co-defendant case in which this defendant was charged under the aiding and abetting theory as opposed to a principal actor. Well, I understand that legally those are the same. I think it's important for the court to note when we're talking about bonds that that's how he was charged under that theory. However, obviously, the court is also aware there was a very high likelihood of this potential resolution to be both life offenses being pled down to a 5-year accessory after the fact under the HYTA status. My understanding that the defendant's family is here in court with him today. They were in court with him last time. And speaking of Mr. Berry, the defendant has a stable home to go home to. So we would just be asking for GPS tether with victim notification.
Mr. Berry.
I agree with all that and further echo that his mother is here. She's in the courtroom today. Under bond factors to be considered, whether as a member of the community can vouch for him and be responsible.
Speak up a little bit because it's the band.
Thank you, Your Honor. Under the court rules, as far as having someone of the member of the community that can vouch for him and be responsible for him, she is willing and able to do that. She has indicated to me that he would be living in her home. She's going to make a run. Sure, she runs tight ship. He follows, any rules and conditions set forth by this court. Both spoke with him as well as his mother about one of the important, well, I guess all conditions are important, but one of the conditions is not to talk with any of the co-defendants or any other restricted parties or the alleged victim in this matter. And he indicates to me that he understands that completely. He has absolutely no intention or desire to do so. He's committed to following conditions. The court can put, would like to do a tether, a curfew, do that as well. He understands right now he's not accepted any kind of plea agreement, nor is there one that's going to be required to be given to him, especially if there's any kind of violations between now and this next court date. He understands that, and he's not trying to mess anything up.
Was he living with his mom at the time of the alleged incident?
I was living with my mom, but I wouldn't.
That's what it said in the pre-trial services report. So that does make me feel like something changed.
I understand, Your Honor, but you're taking, that doesn't.
You use that as your argument. I didn't.
Sure.
You said that he's going to live with his mom. She's going to run a tight ship. Wasn't he living with his mom before then?
Well, I don't know if the court, hopefully the court's not assuming guilt, but beyond that.
I'm just repeating back what you said.
Well, I know, but you're doing it with the presumption that the implicit that if he's charged with this act, that somehow she didn't run a tight ship.
If I may.
I'm trying to get away from that. My point is, if you do a curfew.
You can go back and forth with me with this if you want to. I'm repeating your statement. And that is that he lived with his mom, and if he's released he's going to live with his mom, and if he's released with his mom, then she's going to run a tight ship. My question was, wasn't he living with his mom before then? And you're the one who got defensive because you could have said whatever you wanted to say.
The court did have a follow-up question.
Yeah, I said, how is that a difference? What has changed?
And I was trying to explain.
Explain it without being argumentative.
Well, then my response to the court then, why would it need to be any different? Is the court?
Because you're telling me that one of the things I need to consider is that he's going to be released to a member of the community that can help supervise. I'm trying to understand how is that different from what happened at the time that he was arraigned?
Why would it need to be different?
Because that was taken into consideration at the time he was arraigned.
I may, Your Honor.
No.
Yes, it was. It's in the bond recommendation.
I don't know that this court.
I'm done talking to you.
If I may, in reviewing, and obviously I understand this is the defense, but in reviewing the interviews with the defendant, the co-defendants, the witnesses, well, and this is my understanding, so please correct me if I'm wrong, Mr. Berry or Mr. Simpson, but while Mr. Simpson's address and residence was with his mother, he wasn't necessarily staying there.
That's my question.
Now,
this said he was. I'm looking at what the magistrate considered at the time. I'm asking you, what is the difference that you want me to now consider outside of the offer and what she said? I'm not looking for you to try to decide what I'm thinking.
Well,
you don't know what I'm thinking. I don't know anything about the facts. So how could I think anything?
Well, then how can this court put me? I wasn't.
I asked the question.
May I respond?
No, because I already told you I was done talking to you because you're argumentative. So I'll ask your client. Was you living with your mom before this?
I wasn't. That was the address.
You can tell me and I can respond.
No, I'm asking your client.
I'm going to direct him not to respond to.
Oh, okay. Well, then I don't have anything to consider then.
because you want to argue.
I wasn't.
And I'm trying to get
I wasn't at
information.
the arraignment. I couldn't. answer
I'm
that
trying to get information.
How could I possibly answer if I wasn't at the arraignment?
No, you wanted to assume
As
that
the
I'm
court.
taking a position when I'm trying to get information.
The court wants to be.
Ma'am,
retaliatory
are you,
for no
you've been
reason.
here the whole time. I'm not talking to you because you want to create an issue.
I don't.
And
want
it can go there if you want to.
I don't know where it's supposed to go.
It's supposed to be that you answer the questions without saying, well, I hope the judge, you don't know what the current, I don't know anything about the facts. How would I know anything? I haven't even read. Talk over me again. Talk over me again. Go ahead.
Okay.
Go ahead. You want to run this? Or you want to answer my
I can't make
question?
this court happy, so I'm gonna.
No,
let the
you
court-
can, you could.
I've tried.
I've seen you do this in multiple courts. Do you know that? I've seen you do it to multiple prosecutors. And I've seen you do it on multiple records.
So the court is
It's
mad
not,
at me
I'm not
and
finished.
wants to-
I'm not mad at anybody, but I'm not going to allow you to be argumentative or overtalk me. I asked a simple question and I wanted a simple, direct answer. How is this different from what was provided before at the time of arraignment? A simple answer could have been what he was suggesting. Well, I wasn't really staying with my mom before. But that's not what you said. Ma'am, what's your name? You're his mother. Okay, what's your address?
1610 Chestnut.
1610 North Chestnut.
Yes,
Is your son employed? He was at the time of arraignment.
yeah, he had just got the job.
Okay, so he doesn't have a job. You're still 19, correct?
Yes, Your Honor.
Bond is set at 75,000 personal recognizances with GPS tether and victim notification if possible. You also will have a curfew between 6 p.m. and 7 a.m. unless there's evidence that you are employed during those timeframes, okay?
Yes, Your Honor.
You will be residing at 1610 North Chestnut with your mother. I have a phone number ending in 6175. Is that accurate?
Yes, Your Honor.
Any additional matters for the record?
Yeah, if I just make clarify, just because I have the register of actions printed out and it has 1016 North Chestnut.
Yes, but he might have given the wrong address.
Okay.
That's what we had to. Or the magistrate could have wrote it wrong.
Sure.
Any additional matters for the record?
No, Your Honor, thank you.
No.
The magistrate didn't write it wrong. That's on the pre-trial release too. And you're all set.
Bye.
Not the wrong one. So what? These are always too much. They didn't say one who got in a fight with Nagel? Yes, ma'am.
My address is 1016. I just moved here. I had to Google my.
That's why I wanted to clarify. I didn't want him to have the wrong address.
1016 North Chestnut.
Yes, ma'am. I want to address that before I leave.
No problem.
need the, other file. too.
Good afternoon, y'all.
Good afternoon, how are you?
Good, how are you?
I'm well.
I was happy to see that the air here was not too bad. 'Cause outside,
You said what?
outside is bad.
Really?
It's really bad.
Oh, you mean outside?
Yeah.
Oh, no, I know, it made me nauseous.
It's really bad.
No, it's crazy, it's getting worse. It's like this in Boston too. I think they're trying to kill us at this point. Cause this ain't, I mean, cause why?
You got the ass.
About 75% today. Yeah. That's I mean, you know, all right, you know. I can get it over me. I heard I know, no. Okay. I said, what's your name? No.
Who's here, Mr. Stoudemire?
I am.
Okay. And then, Ms. Robinson, you have,
I have Mr. Dickey and Mr. Ward.
okay. And then who's here, who's supposed to be on Idris? Do we know?
I believe Idris was.
I forgot. Yeah, and we don't have an interpreter, so essentially you're gonna have to waive it, Mr. Idris's appearance for this purpose. Because we couldn't get one in the 5-day period.
Yeah.
I think it's in
Maybe go outside.
There's only 2 red envelopes. These are old stuff in it. January 9th. I got them all together at the same time. March 2026. I looked at this one already. What's this, maybe? Is McConnell supposed to have them?
Yeah, all of them. I got three.
Lord. This is McConnell. That's all McConnell. One is. I think it's the one that's in easier. Yeah. Yeah. This is the state of Michigan. Where's Ross? We called him. On the record in the matter of the state of Michigan versus David Studemeyer, have 25-02049 FY appearance, please.
Ross Marshmeyer for people.
Assistant Public Defender Jessica Straub on behalf of Mr. Studemeyer, who is here with me.
The court is in receipt of a report. It was dated prepared June 29th. The court received it as, it looks like July 6th. At least that's the date stamp on it. And the report should have been sent to both parties. Did you get it?
Yes.
Okay, and for the record, Mr. Studemeyer is present via polycom in Ingham County Jail. The body and conclusion of the report is that the defendant is still incompetent to stand trial, but they believe that he is restorable. And within the time period remaining by the statute. Any reason to make objections to the body or the conclusion of the report?
None for people on it.
None from defense, Your Honor.
The court will adopt the report and incorporate it into the court record. Of order of incompetency will be entered, as well as an order for the defendant to undergo treatment to see if competency can be restored within the statutory time frame. The matter will be set for further review date, as well as Mr. Stoudemire's pending misdemeanor files. Any additional matters on this record?
Nothing from the people.
Your Honor, it is my understanding that there is a time limitation for restoring Mr. Studemeyer to competence. I do believe it is either 15 months or 1/3 of the maximum sentence. I do believe that Mr. Studemeyer has now been in custody for longer than that. 31 days is what my math comes back as being the maximum. The defense would move to dismiss his misdemeanor.
Mr. Marshmeyer.
I mean, it does sound like he has been in custody longer than the maximum penalty in the misdemeanor cases. So I don't think I have an objection today.
Okay, let me just double check. He never posted his bond, is that correct?
And I am not sure, Your Honor.
Does he have bond on all of these?
I do believe he has a felony file. I'm not sure if he has on his felony.
Okay, I see here, it says defendant, when he was arraigned on this, I think he had. Okay, their competency wasn't completed on this until April. And I think that's because we alerted you the last time you made this motion that he actually was not
That is correct.
under competency on these.
That's my
Just making sure I have it in each file. Right. That one was in January. Your motions are granted as to the misdemeanors. Without prejudice. Okay. So you do have to recognize that people have the right to reissue this within the statutory time frame.
Yes, Your Honor.
Strategically, don't know if the dismissal was in his best interest, because if they do reissue this, once he's competent, he doesn't get the benefit of credit time served. Because the case is now gone. He's not getting out of jail because these were dismissed. So that's up to the prosecution, obviously, if they reissue. There's obviously victims alleged in these matters, and so they may not have a choice but to reissue them.
Well, my hope, Your Honor, is that since he has been in custody, as I understand it, since late in 2025, that he would have at least been perceived to have paid his dues under these files. I know technically the way that the law is written, that wouldn't be the case.
The paid his dues and potential restitution are not the same.
True.
Because there's a malicious destruction to building in two separate files and salt and battery. So. Mr. Stoudemire, you're all set for today. Your felony will continue and will get a review date.
Okay.
Excuse me?
I said, okay.
Thank you. You're all set. I don't know. I think that was Mr. Idris.
No, it's not a defense motion. This is a defense's motion.
Sorry. What is it? Okay. Well, you're not talking about me. Yeah, no, I'm talking about there. I'm like, you know what? Okay, very good. Okay, this is 1, 2. Mr. Idris has a number of things here, correct? State of Michigan. I'm sorry, this might be City of Lansing. City of Lansing versus Abdul Rahman Idris 25-012202501223 and then 25-01477 appearance please.
Elizabeth Kirkmoley on behalf of the city of Lansing.
Assistant Public Defender Justice Straub on behalf of Mr. Abdurrahman, who is here remotely.
Okay, he is here remotely. However, he does require a very specific type of interpreter. And due to the statutory nature of having to set this within 5 days, we were not able to get an interpreter. So are you willing to waive his appearance, at least audibly for this purpose?
Yes, Your
Well, she has to do it.
Honor. Sorry, Your Honor.
I didn't hear you, Ms.
I
Straw.
said yes, Your
Oh,
Honor.
okay, thank
So
you.
sorry.
Okay, all right, so I do have a report from the Center from Forensic Psychiatry, July 6, 2026. I did both of you get a copy of it?
Yes, Your Honor.
Right now, Your Honor, I'm not actually the attorney of record for this file. Yes.
I sent it to her. Oh, yeah, we sent it to her.
7-9. Okay, I do have that now, Your Honor.
Okay, the body and the conclusion of the report is that the defendant is incompetent to stand trial, but they believe that he could be restored to competency. They say in the time period allotted by statute. Any reason to make objections to the body or the conclusion and move forward?
Your Honor, I feel like we were remiss if I didn't point out that on the last page, the very last sentence is therefore it is the opinion of Mrs. Samner that, therefore.
Oh, that he could not be restored in the statute.
Yes.
I was gonna say there's no possibility it's a city ordinance case that he could be restored in the statutory time frame. So he's also been in custody on an open alcohol in public. At least since November, it looks like.
That moves to dismiss this case, Your Honor.
Any objection?
No objection, Your Honor.
No dismissals required because I think these are all citations. Let me double check though. Cases are dismissed. Mr. Idris is all set. We might have to call the deputy to let them know though. Does he have anything else pending? I don't know this is it.
It's over. You're.
All these multiple files, let's see. This is board. Put that back over here.
and McConnell. Mr. McConnell, can you hear us?
I can.
Okay, this is the matter of the city of Lansing versus Dylan McConnell. I have 20L2568622, 25-00947OT, 25L2937813OT, and 25L2937822OT. Council appearance, please.
Elizabeth Crook-Molly on behalf of the City of Lansing.
Assistant Public Defender Justice Straub on behalf of Mr. McConnell, who is here remotely.
Okay, the court is in possession of a report from the Center for Forensic Psychiatry. It was prepared on July 8th, 2026. Did council get a copy?
Yes, Your Honor, the city did.
Yes, Your Honor, defense also did.
Okay, the report opines that he is currently incompetent, but they believe he's restorable, but he has been refusing to participate in the services. Any reason to object to the body of the report or the conclusion?
No, Your Honor, not from the city.
Not from the
Okay. The court will adopt the report or incorporate it into the court record.
Breakout room with my attorney?
You want to meet with your attorney?
I do.
Okay, you can go off the record for you to do that.
How long in your honor?
No problem. This is all licensing. He must be in custody for something else. It's gotta be. This is licensing. Your attorney's logging in now, sir, okay? Dennis Edward Dickey, 26-01116, appearance, please.
Ross Martin on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Dickey.
Okay, Mr. Dickey has an examination scheduled today. This was for an assault. So this is to great bodily harm, less than murder, domestic violence, and assault and battery misdemeanors accompany the file. How are we proceeding?
Your Honor, the people are going to need to dismiss this case through lack of contact with the necessary witnesses.
We would make a motion to dismiss, or
No objection to their.
no objection to their motion, I guess.
Okay, motion is granted without prejudice. The people do have the right, however, to reissue the charge against you. Do you understand that? Sir? I have to hear your response.
Yes, ma'am.
Okay, do you have any questions at this time? Okay, and you are on tether, so you need to go back down to have it removed, or you can go to the tether company directly. Either way, we'll notify JSG.
Your
that
Honor,
you're-
you've been to.
Oh, I did? Well, you're good then. You don't need to go have it removed. Okay, I will get you a copy of dismissal in just a moment, sir, okay?
Thank you.
You're welcome, sir. On the record, the matter of the state of Michigan versus James Lucas Ward. I have 23-01772 and 26-01086 and 26-01023. Appearances, please.
Ross Marsh, speaking up for the people.
Karen Robinson, Assistant Public Defender for Mr. Ward.
Mr. Ward, did you change your appearance?
Yeah.
I was gonna say, I thought you had hair last time I saw you. Okay. All right, so this is a continuation of preliminary examination on file number ending in 086, correct? No. Yes, that's the one that we need to continue. One of these we never did anything on. Which one is it? Okay, it's the 086 is the continuation. We
Yes.
never had a witness on 023.
That's correct.
Okay, as to 023, your office has still not had any contact with the witness, correct?
Correct.
You would make a motion to dismiss on that file, Judge.
Motion is granted without prejudice and the court will dismiss the bond violation. Okay, as to the other remaining charge, I think this was reset because of concerns about domestic violence, third offense notice, which I don't believe is an issue that requires an additional witness. You can proceed to argument.
Well, Your Honor, as we discussed previously off the record, this exam was conducted by Mr. Smith. And Mr. Smith did not leave any notes on the file. I did not know the exam happened until I was talking to the victim last night. And she asked why she would testify again. And I said, what do you mean again? And all the information I have about what happened at the last night, I did send Mr. Smith an urgent email asking what happened on May 21st, to which he did not respond. So I'm flying blind here today.
This the small.
That must be it. Yeah, maybe he couldn't see the email through the smart.
It's cloudy.
Ms. Robinson has told me a little bit about what happened, but ultimately I'm just going to have no choice but to defer to the court. That's really all I can do is based on my conversations. It sounds like there was probable cause to establish these felonies. I was told that Mr. Smith needed to get certified judgments of sentence on these DV3rds, even though that is a sentence enhancement that doesn't require finding. And it sounds like he also wanted to present a witness to admit those, even though they were educated. So I'm going to politely request that the court find this over. And that's kind of all the argument that I can make.
Your Honor, we would leave it in the court's discretion.
Okay, well, I have here, for your information, Mr. Ward, I do recall the nature of the exam from the previous court date. Again, the burden is on the prosecution at the time of the exam to establish whether or not they have sufficient probable cause that the felonies you're being charged with were committed, and then sufficient probable cause to charge you as a person to have allegedly committed those felonies. You understand that? So this is not trial. They don't have to prove each element beyond a reasonable doubt. It's a relatively low and flexible burden. And I'll also be the sole determiner of any credibility issues. So we did have testimony previously from Teresa Averill. She testified that on or about the date of March 11th, 2026, she was at the address of 913 West Holmes in the city of Lansing, Ingham County. Making venue in this court appropriate, she identified the defendant in court, Mr. James Ward II. She stated that they had a long-standing relationship. It sounds like the relationship has levels of intimacy based off her testimony, and that she at the time was working, and that Mr. Ward appeared in the parking lot of her job at that date and time. She said she was taking out the trash. And that there was a maintenance man who was there telling Mr. Ward that he needed to leave the property. She described her place of work to be a needle clinic and a methadone clinic of some sort. That the defendant's truck was near the dumpster. There was some words that was exchanged at the time, and that the defendant yelled for her to get away from his truck. He hit the gas, she says, and accelerated towards her kneecaps. She said that he stated at the time, "I will kill you too." I guess it's when the coworker came out to try to intervene. A statement was said, "I will kill you too, you effing nigger loving bee," and bumped her with his truck. She again testified that she has known Mr. Ward since 2006. And there was some talk or concern about who he was in the vehicle with at the time, which was another woman allegedly. And so we held her testimony from the co-worker, Tanya Harris. She stated she was in her office when she overheard the maintenance man yelling. She saw Miss Averill pushing back on the truck hood, yelling, "Stop, you got my knees." And then her knees were pinned, and that she said that the alleged victim was yelling that "you're hurting my knees," and that she described, she being Miss Harris, described Miss Averill's knees being under the bumper of the vehicle. That the defendant did eventually stop, but then the defendant jumped out of the vehicle and started yelling derogatory statements directed at her. The defendant was charged with count 1 with domestic violence and or knowingly assaulting an individual. Third or subsequent offense known as which is a felony. Again, the nature of the relationship described between him and her by Miss Averill was that of a dating relationship on and off. And at the time of the alleged incident, and that he assaulted her with his vehicle. The court is satisfied that there's sufficient probable cause as to count 1 of domestic violence, third offense notice, that will be bound over to the circuit court. There's also a assault with a dangerous weapon, that being a felonious assault, and that the defendant used a dangerous weapon be in his truck. But without intending to commit the crime of murder, actually inflict great bodily harm less than the crime of murder. Again, there was testimony that he accelerated his vehicle and had her knees pinned under the hood, under the bumper of the vehicle, and that he bumped her with his truck. So the court is satisfied based on the testimony evidence that there's more than mere suspicion as to count two that will also be bound over to the circuit court. The bind over date in this file is going to be July 29th. That's the date the circuit court's receiving the file, not a court date for you. Okay, Mr. Ward? Your next court date is going to be a pre-trial in the circuit court. Your attorney will be made aware of that and she'll remain in contact with you, okay? Do you have any questions at this time? And I think you also have a probation violation, is that correct? I'm sorry, I cannot hear you. We have a lot of fans going on.
Pretty sure you gave me time served on that last time. I was here.
It might have just been set for show cause because you owe money. That might be what the issue is. You're being held on this. Is that what the issue is?
I was being held on a remand for the time violation.
Right. so
Okay, which is just dismissed.
Yes, that's almost dismissed. So you also have probation violation.
Yeah, she gave me the show cost for, I think it was $305 to discuss when I could pay it.
Yeah, this was set for show cause on this, so the show cause had to be about $305. That's what it says, $305 set for show cause. And then, because he did get credit time served. And then he has a bond 10,000 cash surety on this. Is that correct?
For the 10-8-6 case, yes.
Yes,
correct.
okay. Okay, so are you intending to post that bond, sir?
I believe so.
Okay, so when do you think you'll be able to make a payment on the fines and costs on the other side?
Get out, it'll be within the next couple of weeks after they out.
You're gonna pay the whole thing within a couple of weeks?
Yeah.
I'll note that you'll pay within 30 days. If you need an extension, you have to make the request, okay? Otherwise, it could go to another show cause or a bench warrant, okay? That will resolve that one, and then this. Matter will continue. Any additional matters for the record?
I think for people.
No, Your Honor, thank you.
Thank you. You're all set. Is that your witness?
Yes.
Yes.
And this is Haley Burton's, a new victim advocate in our office.
Hi. Oh, did you finish with Mr. McConnell?
Yes, I did.
I didn't finish with him. Did they let him leave?
That I don't know. I did tell him we were going back to the main room.
But that's not March Mina's case anyways. Oh, March Mina. Okay, back on the record in the matter.
of the matters with Mr. McConnell, you did chat with him about his concerns, correct?
Yes, sir.
And I don't know if they had anything to do about, or with regard to the statements in the report indicating that he has not been willingly participating in the services. But nonetheless, do we need to make any objections to the finding or the conclusion of the report?
You do not.
Okay, very good. So the court will adopt the report, incorporate it into the court file, and it says that he needs to be treated for competency. Let's see. That was from July. I just don't know that we have time under the statute, and I may need to order him to be PRT if he's not going to participate.
Well, it is my understanding, Your Honor, that he has a felony file, so I don't believe that even if his misdemeanors were dismissed, that he would be out.
Well, it's not even just about that. It's just that the report says that he is not willingly participating. It says that the concern is that the defendant may be a person requiring treatment under the statute or may meet criteria for judicial admission as defined in MCL 330.1515, which is what I just had to do on the last file. If he's not going to be able to be restored within the statutory timeframe, I'm going to at this time order him to undergo treatment. And if he's participating willingly, then that works favorably. We won't have to worry about a PRT. Does he have a competency situation pending on the felony?
Yes, Your Honor.
Okay. So that'll be the order of the court. We'll order him to undergo treatment and then see if these matters can be resolved if he is able to be restored. Any additional matters on the files today?
Not from the city, Your Honor.
Not from the fence.
Okay, you're all set for today, Mr. McConnell. Thank you. Can you hear me, Mr. McConnell?
I can.
Oh, yep, you're all set for today.
You can leave, Mr. McConnell. Have a good day.
Yeah.